Is there a Miss Banta in the courtroom? Carol Banta? No? Okay, is everybody aware we are arguing from the middle lectern? We're good? Okay. And we'll start momentarily, okay? The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, 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 all persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, be seated, please. All right, this morning we're going to start with the first case, Appellee versus Rocket Mortgage, and Mr. Jay, we'll hear from you when you're ready.
Good morning, Your Honors. William Jay for the appellants. This case was sent back to the district court to apply TransUnion to the facts of this case. And the district court reinstated its judgment in its entirety. And so this court has allowed us to reinstate our arguments in their entirety in our attack on that judgment. The district court erred by granting summary judgment to the plaintiffs on both the unconscionable inducement claim and the contract claim, and it erred in certifying the class. And I think our fundamental submission is that by following this common business practice, the defendants did not cause any injury to anyone in the class. So I'd like to start with, if I may, the district court's conclusion on TransUnion and explain why there's no evidence that could support certainly a class-wide judgment on the injury question. So the district court had basically one sentence of reasoning about why TransUnion does not control here. Said that all of the plaintiffs paid for an appraisal, a fair, accurate, and unbiased appraisal that they never received. But while we don't agree with everything in the court's prior panel opinion, one thing that the court said we certainly do agree with, and that is that there is no evidence that the defendants breached any obligation to provide a fair, unbiased, and impartial appraisal.
Let's go beyond that. Let's assume that we're reviewing the district court's opinion in the light of TransUnion. Yep. And as I understand it, the district court assumed that the class members paid an average of $350 for an appraisal. And so we'll take that. There's nothing to suggest that that isn't a fair or accurate conclusion. The second statement that it would have to make under TransUnion is that they, in fact, didn't receive a $350 appraisal or an appraisal at all. I think the district court's theory is it didn't receive any. The appraisals were of no value, and I gather the court didn't explain how it could reach that conclusion for class members. And I gather your argument is there's no evidence that any of the class members even ordered an appraisal for themselves or saw an appraisal, or that the appraiser saw it or relied on it, or that it wasn't accurate. That's your position, isn't it?
That's basically our position. That's right.
And TransUnion, you say, requires a finding with respect to each class member of actual damage, not the statutory damage.
Right. Statutory damages, as in TransUnion, are not enough. There has to be injury. And in a case where the claim is we paid money for something, the injury has to be that you didn't get what you paid for.
Well, you know, they paid for an independent appraisal, and they didn't get it. The machinations between Quicken Loans and the appraisers, there's a whole lot of activity and influence on that, quote, independent appraiser. That's their claim for damages, isn't it?
So can I respond to that with three steps? So the first is just to point out what this court's prior decision on the breach of contract claim said, that the plaintiffs had not yet proved that there was a breach of any obligation to provide a fair and impartial appraisal.
Well, isn't that an evidentiary issue to be decided?
Well, recall, Your Honor, the district court granted summary judgment for plaintiffs and found no factual dispute. There's no class-wide evidence that could sustain that. And I think that's what this court recognized in its prior analysis of the contract claim. But more fundamentally, and this I think gets to Judge Niemeyer's question as well, that if the theory is we paid for something that we did not get, they all received an appraisal. They all received an appraisal that was fully compliant with the applicable professional standards. And so if the argument is that they bargained for or even expected something over and above what the professional standards allowed, they would need to have evidence of that expectation, and they have none. This court, in its prior panel decision, all it could say was that it supposed, it is reasonable to suppose that there might be such an expectation, but TransUnion says that supposition is not enough. Inference is not enough, especially once you have a class-wide judgment awarding damages. You have to have evidence of standing, and that means evidence of injury. And in this case, that would mean not getting what you paid for. So to your question, Judge Floyd, I mean, the district court completely skipped over that point and granted summary judgment for the plaintiffs without ever analyzing it. Recall that the first time around, the district court thought that the standing of unnamed class members was totally irrelevant and didn't examine it. That, I take it, is why this court sent the case back to...
Of course, the Supreme Court sent it to us.
Indeed.
And we sent it back to the district court to do the analysis under TransUnion. And the district court concluded that its prior opinion did what was necessary.
Right, and to Judge Floyd's question about the sort of the, I think the word you used, Your Honor, was machinations, right? So recall that there would have to be class-wide evidence, right? And so what we showed in our briefs, both before and I think in more detail on this appeal after remand, is that there were any number of instances in which the appraiser himself or herself didn't even see the borrower's estimate, in which the value wasn't based on the appraisal work done by the appraiser, but by a recent sale price, or that the homeowner, him or herself, told the appraiser what they thought the value was worth.
I guess the problem I'm having isn't what the plaintiffs are going after, is the conduct about the way the appraisal was done, not down the road, you know, where there's a foreclosure and you find out you're underwater. They're not going there. They're going in the first step.
Well, the claim is for unconscionable inducement, right? So that our position, right, is that whatever they claim is unconscionable has to have caused them to enter into the loan. And as the court recognized, there's no evidence, the record is devoid of evidence that anyone's appraisals were inaccurate, any of the unnamed class members' appraisals were inaccurate, and that any of the unnamed class members relied on the appraisal figure in deciding whether or not to enter into their refinance loan. And in fact, we've shown in our briefs that there are any number of examples of borrowers who borrowed as little as 8% of the appraised value of their home. And the exact details of the appraiser's valuation of the home likely were not material to any such borrower. Now, when our friends on the other side first tried to come up with a theory for why there was standing, one of the arguments they made was that the deprivation of information was itself an injury. And the Supreme Court, I think, has ruled that out in TransUnion by saying informational injury requires downstream consequences. You've got to show that you were harmed by not getting the information. And so that leaves them with the theory that they paid for something over and above a fully compliant with professional standards appraisal. They don't have any evidence, much less class-wide evidence, that they bargained for, expected, contracted for, or paid for that. Even in the prior panel decision, the court was willing to infer that there was a promise to provide a fair and impartial appraisal, but it held that the plaintiffs had not established any breach of that yet. That's why the prior panel decision remanded on the contract claim. We submit that the dearth of evidence on that point is a grounds for summary judgment in our favor. It certainly can't sustain summary judgment in the plaintiff's favor or certification of an entire class of borrowers.
I'm not sure. We'd have to think this through, but if we limit our consideration to the TransUnion issue, it just goes to the class certification. In other words, if we were to, hypothetically, if we were to, say, decertify the class because TransUnion wasn't fulfilled, then the plaintiffs would still have their claims in accordance with our prior opinion.
Right. I mean, named plaintiffs can certainly, individual plaintiffs could certainly try to establish on an individual basis that they were harmed. And I know that the ALIGs went and got a retrospective appraisal of their home, and they say that that's the basis of their harm. Now, we're not receding from our...
Also, on the, under our prior opinion, we left open contract issues for the court to resolve. And, of course, if that were to apply, we would have to... If we were to do all that, if you were successful, it seems to me, you would get decertification, but you'd have to remand it to have it considered for the plaintiffs and to have the contract issues resolved.
Well, we're not...
Because our prior opinion left the contract issues open, right?
It did. So if you reinstated that opinion, then that's what would happen.
The district court can't overrule our former opinion.
Indeed not, but we're not receding from our argument that we should have gotten summary judgment on both claims. But you're right, Judge Niemeyer, that if the court reinstated that decision, that's what would happen. And on the contract claim in particular, there is one point that I want to emphasize about the prior opinion, which is that the court suggested that it would just be a ministerial exercise to determine damages. It would not be a ministerial exercise to determine...
You could argue that to the district court.
Indeed.
Because our prior opinion, while it's been vacated, was left open the contract issue. And I suppose because it was vacated, the district court would have to start over in some sense. But it seems to me what the Supreme Court directed us to do is to review our former opinion in light of TransUnion.
That's right, but right now there is no decision of this court on all of the challenges that we've raised to summary judgment and on both the statutory and the contract claims. So I think this court either it would need to reinstate its decision or make a different decision on those claims. And the point that I was just making is to argue that if you were to reinstate your opinion on the contract claim, I think it's important to not go wrong on the point that figuring out whether an individual borrower was damaged by the supposed promise to provide a fair and impartial appraisal, that's not just a ministerial exercise, because the court seemed to assume that you could figure out what the true value of the class member's home was in 2004 to 2009 without a retrospective appraisal. And I think just as we were discussing a moment ago, the ALIGs went and got a retrospective appraisal, but the other class members did not. And that's the fundamental problem with the treatment of this case as a class case. And so if the court were to reverse the class certification, then just as you said, Judge Niemeyer, it would be up to the class members to decide whether they wanted to certify another class depending on common evidence to establish standing and the other elements, or whether they wanted to proceed as individuals instead.
Is there any relevance to this court's decision of a couple of weeks ago in Fernandez and Rentgrove versus Rentgrove?
So I'm familiar with that decision. I think what our friends on the other side would say is that that's more like TransUnion than this one. I think that it is a helpful elucidation of the need for standing in a statutory damages case. I think that Baer versus Craig Northrop team, the case we've cited in our papers, I think is closer to this case than the recent decision is, because there and here you have a claim of a procedural violation, and the obligation is on the plaintiffs to establish that a procedural violation caused some harm. And the same is true in the decision that you mentioned, Your Honor. But the reason that I think Baer is even more on point is that in Baer, they're paying for services, and they're claiming, the plaintiffs were claiming that they didn't get the services that they were promised. And this court held that you can't repackage your sort of naked claim of a procedural violation as a failure to provide what was expected just by claiming without evidence that you expected something else. And I think the same is true here, that there's no evidence that they expected an appraisal, that any of the borrowers expected an appraisal that did anything other than comply with the uniform standards. And all of these appraisals complied with the uniform standards. Our friends on the other side, they don't agree with the uniform standards. They think that was insufficiently protective of borrowers. But what they haven't shown is any expectation that borrowers had that they were getting something beyond a fully compliant appraisal.
Is that it?
I think that's all at this time. Thank you, Your Honor.
Thank you, Mr. J. Mr. Gupta?
Good morning, Your Honors. Thank you, and may it please the Court, Deepak Gupta for the plaintiffs. As this case comes to the Court, Judge Niemeyer, I think you're right. The question before this panel is whether the panel's earlier decision is consistent with the Supreme Court's recent decision in TransUnion. And the answer is that it is, and I think this appeal turns on a simple proposition, which is that when someone pays money to someone else and claims that they did not get what they paid for, or that the law did not.
Part was the one I posed the question to your colleague. I think there's evidence that class members paid an average of $350 for appraisals.
Correct, Your Honor.
But the second part is that they didn't get what they bargained for or what was anticipated. It seems to me there's no evidence in the record of that. As a matter of fact, there's all kinds of indications to the contrary that we don't even know whether class members provided their own estimates of things. We don't know if class members were dissatisfied or whether the actual appraisals were inaccurate. In other words, there's no evidence to suggest they weren't dead on. What we have is no further analysis of the class members' standing injury. We have the fact that they, as part of their closing costs, they paid for an appraisal, which was required by the lender. But the lenders, I suppose, were fully satisfied, and the class members got their loans. And so the question is whether, in that whole process, whether the class members were injured. And while we have a fair amount of evidence with respect to the named plaintiffs, the two named plaintiffs, Shays and the Alex, I don't think the district court went beyond just relying on the $350 per person and the assumption that the class members didn't get an appraisal, period. That's what the court said, right?
So I think there's a lot packed into that question, Judge Niemeyer.
Start with what the district court concluded on the TransUnion.
Yes, I mean, I think what the district court was saying is essentially what this panel, what the prior panel opinion said, which is that each and every one of these class members paid this money, and what they paid for is an independent appraisal, and they didn't get that. And I think it would be.
You say they didn't get that, but
right.
The evidence doesn't show they didn't.
Well, the evidence does, and I think it's the same evidence that the prior panel opinion relied on. So at Joint Appendix 919, there's a spreadsheet that was produced by Quicken Loans that shows that it included the estimated value on every appraisal order regarding loans refinanced in West Virginia during the relevant period for all of the class members. That's what the prior panel opinion relied on. And I think a hypothetical might help, because what we're asking is, would this be the kind of suit that would have been cognizable in Anglo-American courts at the time of the Constitution's framing? And this is no different from a case where if I have a business and I hire someone to do an audit of my business, they claim to be the person with all the requisite credentials. They claim to be, let's say, a certified public auditor. They claim to be providing me with the proper independent report, but they're a charlatan. They're not actually a certified public auditor.
We have evidence in this file from appraisers that said they didn't even look at those estimates. So that is one type of class group. We have others who say it didn't influence them.
So
And,
let's.
others say we certified and we did our own work. We didn't pay attention to it.
So Judge Niemeyer, it would be no answer in my hypothetical lawsuit to say, oh, well, the report you got is the same report that you would have gotten, and you can't show downstream effects. The point is, I paid for an independent report. I paid for one that would be reliable.
Well,
it
an
wasn't.
independent report is a nomenclature for a report that was uninfluenced by the homeowner's estimate. That's what independent from the homeowner's estimate. Now,
Right.
we do not know that the class members' appraisals were independent or not.
No, we do, and this is what the
Well,
court.
the only evidence is that they were independent.
This is what the panel held last time around. What it held was that Quicken Loans was.
The court didn't think so.
Well, no, I don't think that's right. I think we should be cautious about reading too much into a GVR order. A GVR order can be acted upon at the recommendation of a single law clerk. It doesn't mean that the court was saying, you got this wrong. It means we issued this decision. My friends on the other side said to the Supreme Court that our theory of standing was a risk of future harm theory of standing. And so the Supreme Court sent it back. But in fact, our theory has never been a risk of future harm standing. Our theory of standing is the most elemental, fundamental kind of theory of standing that exists in the law.
The question of the theory, the question is of the evidence, the record, evidence.
Right, and the record...
And the Supreme Court made very clear that the evidence has to be introduced with respect to to the class members.
Right, and the evidence is the same for every class member with respect to standing. The evidence is that for every single class member, they paid...
Simply, it cannot be true. What if the appraiser never received the homeowner's appraisal?
Right.
It's independent. He makes an independent. So there, in that particular case where he never saw it,
Right.
and therefore could not even have relied on it, your theory doesn't hold. And
No,
we
I don't think that's right, Judge Niemeyer. That's never been our theory. Our theory has never turned on what happened downstream. Once the process...
Actual damage to the plaintiff.
Right, the harm to the plaintiff is the monetary harm of paying out the money for the thing that they didn't get.
But in what sense did they not get an independent appraisal if the appraiser didn't even look at the homeowner's estimation?
So I had that question too.
What's the theory of how that
Yeah.
was not an independent appraisal as paid for?
So if you look in the prior panel opinion, there's the testimony of Dewey Gouda, who is one of the appraisers. He had a deposition, and what he said is that regardless of whether he looked at these values, that Quicken had a whole team at the company that if there was a discrepancy between what he estimated and what they thought should be the value, they would call them up and they would pressure them. And this was a real focus of the prior panel opinion, that the whole process was corrupted by this high pressure tactic of pressuring the appraisals to come in at the values that they wanted. So it's not about whether any one particular person was rendered underwater as a result. I mean, that's why the legislature cares about this. That's why the policy, this practice became universally condemned. But if you're asking the standing question, it's not about what are the potential downstream effects. Just like in my hypothetical case, it's not about, I mean, you could imagine lots of things that would befall my business if I don't get the kind of audit that I paid for. But the more simple theory, and this has been true at Anglo-American law going back centuries, is that when my claim is that I paid you for something and I didn't get the thing that I paid for, and this isn't some marginal attribute of the thing, right? The cases that they cite, most of the cases in their brief involve very, very marginal attributes of something that somebody paid for. Independence was essential, the essential attribute of the appraisal. In effect, what I think the prior panel opinion was holding is that when you charge someone for an independent appraisal, but it is not in fact independent because the values are sent there to the appraiser because they have this whole high pressure unit that's designed to taint the process, that you haven't gotten the thing you paid for. It is as simple as that, and that's why the prior panel opinion said that it was obvious that there was standing here. It's pocketbook injury.
I'm sorry.
Go ahead.
So that theory that you just argued that somebody who looked at it and got pressure, that theory applies to every potential class member?
Yes, because
every one of them got influenced by Rocket Mortgage? Every one of them was pressured to render something other than their professional opinion?
No, everyone paid money for a reliable, fair, independent appraisal.
Right, but you just said the reason they weren't is because Rocket Mortgage put pressure on them if Rocket Mortgage didn't get the appraisal it wanted. Do we know that for every class member?
No, and I don't think we need to know that for Article 3 standing, just as we wouldn't need in my hypothetical, or for example, let's say I hired a lawyer to advise me on a case. My business is in hot litigation against another business that produces the same product. And what I really want is independent advice from a lawyer. And unbeknownst to me, that lawyer's law firm actually represents my adversary. And in his defense, when I sue him and I say, hey, You shouldn't have done this. You shouldn't have taken my money. I wanted an independent opinion that I could take to my board of directors. If he says, well, I didn't go down the hall and look at the files for Company B, that's not a defense. The point is I paid for the independent appraisal. And that was the simple and basic theory. That's why.
I know that's a theory, but you're not focusing on the question. And the question is, they paid for an independent
Correct.
appraisal. That's your theory. The question is, was every class member denied an independent? And the evidence on that could be various things. Number one, the appraiser was independent because he never saw the homeowner's influence.
Right.
Number two, he was never pressured by Rocket Mortgage. Number three, it was indeed accurate. And so we have to have, and the Supreme Court said pretty clearly, every member of the class,
Right.
every member of the class has to satisfy Article III damages.
Correct. And I think it's important when you're thinking about Article III standing to remember one fundamental precept that the Supreme Court has said, and it's in the Fourth Circuit's opinions, which is that you don't conflate standing and the merits.
Let me
And
ask
so-
you this, is the following statement true or not? The previous panel recognized the record does not include evidence showing that every appraisal was inflated. As stated previously, however, there is evidence that every appraisal order was tainted with the BEV values, and the defendants concealed that process from the plaintiff.
That is exactly right, Judge
Is
Floyd.
that your case?
That is exactly right. Yes, that is exactly right. And the theory of standing, I think, once you recognize that, follows logically.
Where do I find that evidence?
So the evidence that Judge Floyd just talked about, I mean, he's describing, I think, accurately the prior panel opinion.
He's basically describing the claim that everybody didn't get what he
Yes.
was tainted. But where's the evidence that class members did not receive an independent?
I think it's precisely.
The fact as
I think
to
it
each
is.
class member.
It's precisely what Judge Floyd described, and I'm happy to go through that evidence again. But I just,
Yeah,
I
go
want
through the evidence
to. What I
again.
want to do, though, Judge Niemeyer, is make
Just a minute,
clear.
would you accommodate me, please?
Sure.
Tell me where I find the evidence about absent class members not getting an independent appraisal.
There is none, because that's not true. I mean, every single class member failed to receive an independent appraisal in the same way. And for the reasons that Judge Floyd said.
That the independent, if the appraiser didn't see the homeowner's estimate, then it's independent. And if A-League didn't, if Rocket Mortgage didn't pressure him, it was independent.
No, that's not at all what I'm saying. I don't want to be misunderstood. And I think.
Then tell me, why isn't, if the appraiser did his appraiser without influence from the homeowner and without influence from Rocket Mortgage,
Right. I think.
isn't that independent?
I think, Judge Niemeyer, what you're doing
Just
is
a minute.
conflating.
My question is that independent?
No,
Why not?
because what West Virginia law made the judgment and what this court found.
Factually, why isn't, if an appraiser gives an appraisal
Right.
and did not see the homeowner's estimate and was not pressured by Rocket Mortgage,
Right.
and he gives an appraisal, why isn't that appraisal
So,
independent?
so think about the hypothetical I gave you about the law firm. It would be the
Can
same
you
thing, right?
just
You wouldn't
stick with-
say.
Can you stick with what my
I'm
question?
trying to, because I think there's a premise baked into a lot of your questions, which is that the downstream harms have to have manifested in a particular way. What we're saying is that they didn't receive the thing that they were supposed to receive because essentially the product was a kind of process, right? It was an independent process. It's characterized by its independence. It's the whole reason you have appraisals. If you didn't want independence, you would just have the lender say, hey, we think the value is X, and then that would be rubber stamped. The whole point is that there's an independent appraisal. The same thing for the advice of lawyers. The whole point is that lawyers have a duty to their clients, and they're not supposed to be working for the other side. And it's no defense to say, oh, well, I didn't look at those files. And the same thing with the certified public accountant hypothetical. So I think that your questions, Judge Niemeyer, they're really about the merits of the underlying claim. And I think it's important.
The question is, I'm looking for evidence that every absent class member was damaged by paying $350 for an appraisal.
Right.
And the damage is that the absent class member didn't get an independent appraisal.
Correct.
And my question is, hypothetically, if the homeowner's estimate, which you're challenging, and the pressure from Rocket Mortgage did not occur with respect to an absent class member, that class member got an independent appraisal, and we don't know in this record whether that's so or not.
I think, Judge Niemeyer, your questions rehash the debate between your dissenting opinion and the majority opinion on the merits of the underlying claim, but it is important to keep standing separate.
We are the A-Leagues. There's evidence, quite a bit of evidence about the A-Leagues and the Shays. What happened, whether there's a telephone call, whether they saw the appraisal, the reappraisals. There's evidence in that.
Right.
Now, I did disagree with the notion. I thought that the appraisers for the benefit of the lender, and the lender made the loan, and the loan was taken out. That borrowers were happy, they paid back the loan, and it served, they just weren't injured. That was my theory. But setting that aside, I mean, your theory is that they paid for an appraisal and didn't get the independent appraisal.
Exactly.
And my question, just a minute, and my point now under TransUnion is that we do not have evidence that every class member got an influenced appraisal. That was
Yes, we do. We know that every class member paid for the appraisal. We know that with respect to every single class member, the amount was sent to the appraisers. We know that Quicken had a standard practice across the board of pressuring appraisals when the appraisals were not what Quicken wanted them to be. And that is not a fair or reliable appraisal. It's not something, what they paid for is a fair or reliable appraisal that they could take to somebody else and say, hey, there's a fair appraisal. You can't do that.
You just don't have the evidence that what you just said is true.
Oh, absolutely do.
Every time Rocket Mortgage pressured the appraiser, every time the borrower's estimate affected the appraisal.
No, I'm not, that's right, Judge Bell.
You have to show that, right?
No, I disagree. I think that when the point is that the appraisal was tainted and corrupted, the hallmark, the whole point of an appraisal is what you're buying is independence. And they didn't get that independent appraisal. It's not something that they could take to a bank or anyone else and say, hey, this is a truly independent appraisal. And that is the thing that they paid for. And Article 3 standing is not any more complex than asking at the time of the framing of the Constitution, if someone went into a common law court and they said, I have paid money, and now I'm alleging, and again, what they allege is the merits. I am alleging that they should not have charged me this because it was unlawful, and because I did not receive the thing that I paid for. I didn't get the benefit of the bargain. I didn't get the product I paid for. That would be a claim that would easily have been cognizable, and TransUnion verifies that. TransUnion says that the most obvious form of standing is monetary harm, is pocketbook injury. And the only reason we're here, I think, is that my friends on the other side in their cert petition mischaracterized our theory of standing. Our theory of standing has never been about the downstream risks or what ends up happening in the process to any particular person.
That the Supreme Court didn't read our opinion.
No, I think we should assume that the Supreme Court read the opinion.
Supreme Court granted the GBR, they read our opinion.
I think we should assume that the Supreme Court read the opinion, but I also do not think that we should assume that the Supreme Court was concluding that there was something defective about the opinion. And in fact, in most grant, vacate, and remand orders—
I was addressing your notion that the petitioners misrepresented, so the Supreme Court relied on a misrepresentation.
Oh, I'm not— to be clear, I think what the way that the cert petition worked, and you can see this in the beginning of their opening brief in this appeal, is to recharacterize what we are alleging is something much more complex, which is that it's a causal chain that turns on all sorts of things that end up happening. And I think most of your questions, Judge Niemeyer, have been about that. But that is not at all what we're saying. What we're saying is something much more simple, which is that it has always been true, and this is why they cannot really identify cases where this is not true, where when somebody pays money and claims that they didn't get the thing that they paid for, they at least have Article III standing to come into court.
That secondary aspect is what we're focusing on. You keep assuming it, and you can't assume it without evidence.
I'm
That
certainly
is
not-
that they didn't get what they paid for.
Right, and they didn't get...
The question is, and you say what they claim they should have gotten is an independent appraisal.
Correct.
And the question of independence depends on, under your theory, whether it was influenced by the homeowner's estimate or whether it was pressured by Rocket Mortgage.
The judgment, and this is the merits now, the judgment that West Virginia has made, and this court made a correct, eerie prediction of what West Virginia law is that when you send these estimates to the appraisers, you have irredeemably tainted the process. It's an unreliable estimate that's now universally condemned and not
The Supreme Court
permitted.
rejected that as damage. I mean, that is a very type of thing. And in Bear, we did, and in Spokane. These are all statutory types of structures and damages that have been prohibited. But beyond that, the plaintiffs have to show actual injury to themselves beyond the statutory violation.
They absolutely do, and they absolutely have, and that is through the payment of money. Thank you.
If they got an independent appraisal, did they have any concrete harm?
If they had gotten, so counterfactually, imagine that they had gotten an appraisal where there was no buyer estimated value, there was no pressure team that tainted the process, and everyone acknowledged this is a fair and independent appraisal of the type that should be provided, we wouldn't be here. Thank you.
All right, Mr. Jay?
Thank you, Your Honor. Just a few points in rebuttal. The first is just to highlight what my friend said in response to Judge Bell's question about the so-called pressure team. That's not class-wide evidence. They don't have evidence that every single appraiser was pressured, especially because many of the appraisals did come in below the borrower's estimated value, precisely because appraisers don't take those estimates seriously. And we've cited ample evidence, pages 16 to 17 of our brief, showing that that's not class-wide evidence and that many appraisals don't even rest on the appraisal work done at the time. They may rest on a recent sale price, for example. Second, Mr. Gupta has no answer to the question, how can the appraiser not be independent if the appraiser didn't see the number on the order form? And the evidence in the record from an appraiser who did appraisals for class members, Mr. Judy, is that often he wouldn't see the the order form before he did the appraisal. He'd be sent out on an assignment because the assignment would be written up on a whiteboard. So that's in the record, and there's no answer to how an appraisal cannot be independent if the appraiser has not been influenced. Now, further point is that applicable professional standards recognize that appraisers are knowledgeable professionals. They're signing a statement under penalty of perjury that they've not been influenced. But even if you set all of that aside, many of them did not even see the appraiser, and there's no way of knowing how the estimate. There's no way of knowing how many did or how many didn't, precisely because there's no class-wide evidence that's been put in on that point. And that, I think, disposes of our friend's argument that every single class member got a non-independent appraisal. Last point is just that our friends on the other side say that we don't have any cases in which there was they paid money for something and claimed that that's not what you got. That's exactly what this court considered in Bear, where the argument was, I wanted independently sourced settlement services, and I got instead tainted services because of a kickback. And this court said, you have to show some concrete harm, not just a procedural violation. So the most that our friends on the other side have established that they are claiming is a procedural violation from sending the number to the appraisal company. They can't even establish that the number got to the appraiser. So this is just like TransUnion's example of the swerving motorist, where if the plaintiff drives home and was exposed to the risk of a swerving motorist but didn't get hit, that plaintiff is lucky but not damaged and doesn't have standing. And the same thing is true here. The most that Mr. Gupta can show with common evidence is that by sending the number to the appraisal company, there's a possibility that it might have been shown to the appraiser. But a possibility is not enough. And without class-wide evidence, they can't have a class certified on this Article 3 standing point. Unless the court has any further questions?
Thank you, Mr. J.
Thank you, Your Honors.
Yeah.
We'll come down and greet counsel and then proceed on to the next case. I was going to say slowly, but you could invite them up too.
Thank you,
ready.
Your Honor. Good morning. I first want to address the unusual
Why
standard
don't you
of
pull the
review.
mic down a little closer to where you're
Okay.
talking? Yeah,
Yeah.
good show. Thank you.
Okay. So can you hear me? Okay. The standard of review is important and unusual in this case because it is not a typical 2254 case, which is governed by as the court knows, a highly deferential standard of review, the typical 2254D case. This case is governed by the de novo review standard because this case is governed by the Supreme Court's decision in Martinez versus Ryan, a 2012 decision which governs this case. And by the way, the Commonwealth doesn't dispute that that case governs and that the standard of review is de novo. So that's important. In other words, the issues that are being raised here in this court and in the district court were never raised in the Virginia State Court. So you're not reviewing a Virginia State habeas decision. That's why the de novo standard of review applies. So the district court judge in Abingdon, Judge Jones, agreed with us that Frizzell satisfied the first prong of the Strickland test, basically because, and indeed even the defendant's attorney admitted that he fell below the Strickland standard of performance when he failed to object to the prosecutor's repeated, at least 3 times, and maybe more than 3 times, repeated efforts to shift the burden of proof to the defendant at trial. So there should be no issue about that, and the government has, the Commonwealth has not raised any issue in regard to that. What's at issue here is the judges and the Commonwealth's position that Frizzell did not satisfy the prejudice prong, the second prong of the Strickland test. And that's where the district court erred. The district court spent only a quarter of 1 page of a lengthy decision discussing its conclusion with respect to the prejudice prong. And I submit that the district court's very brief discussion is not persuasive.
Well, let me ask you in terms of how this thing went down. Make sure I'm correct. The trial judge charged the jury first, and then they made arguments. And then there was never any curative instruction about the argument of the Commonwealth's attorney. Is that correct?
Correct. Yes, that's correct, Your Honor. And also there was never any evidentiary hearing in the district court in Abingdon. So no evidentiary hearing about anything. And that's also.
Which statement are you addressing when you responded to that question? Which statement is this relating to the may infer versus the law infers, or are you talking about intoxication versus premeditation?
I'm talking about all the issues that were raised in
when you answered the question, I mean, what were you referring to?
I'm referring to all of those issues that I raised in my briefs, Your Honor. In other words, it wasn't just that the government, the prosecutor and the state court tried to shift the burden to the defense with regard to the intoxication.
That's what I thought you were addressing. Yeah, that one seems to be the more substantive claim that you have, in my judgment.
Well, that's what the district court said. But I think it shouldn't be ignored that the prosecutor also directly contradicted the trial judge's generic instruction, which was correct, which was on the issue of whether there's only a permissive inference, or you must assume that a person intends the natural consequences of what he does. Yes. Yes, sorry.
Well, I beat a dead horse on intent because the prosecutor later recognized that he was going down the wrong way, and he corrected himself. But he didn't do it on the intoxication issue. Isn't that right?
Well, he sort of corrected it, Your Honor. But, you know, who knows what the jury made out of all that when somebody first spends a lot of time saying something incorrect and then says, oh, by the way, you know, I mean so-and-so. So, I mean, that by itself would be a relatively weak case. And so I agree with Judge Niemeyer about that. If it was only that error, I wouldn't be here. But
with respect to the lack of curative instruction, at the close of the arguments and before the jury began deliberations, the court said, again, your verdict must be based solely on the evidence that you've heard in the courtroom and the law that I have instructed you, and then sent the written instructions back with the jury. So didn't the court essentially have the last word on what the law is?
No, Your Honor, because those instructions that you were just quoting were made before there was any closing arguments in the case.
No. What I just read, your verdict must be based solely on the evidence you heard in the courtroom and the law that I have instructed you on. Was between the closing arguments and the beginning of deliberations.
That's interesting.
And then, of course, they went back with the instructions from the court.
I wouldn't call that a curative instruction, Your Honor. That's a repeat of an instruction that I believe the court
I thought you acknowledged that he corrected it, and why would it need a curative instruction even if he corrected it? I mean, he said, I misspoke, and you have the judge's instruction on may infer, and he corrects this, and then the court sends the written instructions back, and if the jury had any question about it, they read the may.
Well, Your Honor, it's very important to note that in the briefing and in the district court, it's not at all clear that the instructions were sent back to the jury. As a matter of fact, the government, the only evidence of that is the prosecutor's statement that, the state prosecutor's statement that he thought the instructions were sent back to the jury. And Mr. Frizzell, the defendant, contradicted that. He said unequivocally they were not sent back.
Didn't the judge say that they would be sent back?
You mean the district court judge or the state judge?
The trial judge.
If he did, I'm not aware of it because I don't believe that's in the record anyplace, Your Honor, what the state court judge said. If he said anything, and I know is I wasn't the trial lawyer, so I don't know what, I can't testify as to what happened. But it is, you'll see in the brief, my briefs that Frizzell stated unequivocally that the evidence didn't, the instructions did not go back, and it was Mr. Light, the state defense attorney, who said, I think the instructions were sent back. I think, not they were sent back. So now if that turns out to be a very decisive issue in this case, I guess you'd have to send it back to the district court for an evidentiary hearing on it. But that's where things stand now.
So what's your opinion of my practice? And as you know, I'm a district court judge, mostly. But before the jury retires to the jury room, I always tell them, if you discern any difference between the law given you by the lawyers and by this court, you are to be guided by this court's instructions. Would that be good enough under a situation like this?
No, Your Honor, because it doesn't specifically deal with the prejudice caused by this state prosecutor's closing, what's called the rebuttal, which really was his closing argument that the defense lawyer didn't have an opportunity to respond to. That's an issue I tried to raise, but a COA was not granted by this court on that issue. But nonetheless, I briefly mentioned it in my opening brief because I think it's important. Because, perhaps there are cases where that kind of instruction would be sufficient, Your Honor, but I don't think it was sufficient in this case because the prejudice was too great from the repeated shifting of the burden of proof by the state prosecutor to the defendant.
Can I address that before, as your time's getting low? I'd like to address the issue relating to the intoxication.
Yes, Your Honor.
And the prosecutor says he cannot prove that he was incapable of doing it, incapable of premeditating. The evidence shows, et cetera. So it puts on the defendant the burden of showing intoxication.
Absolutely.
But right before that, as part of the very, very same discussion, he says, I'm telling you, we've proven attempted capital murder. He was a law enforcement in the performance of his duties. He knew that. He recognized it. It was an intent to kill. It was willful, deliberate, and premeditated. Even though it was a bad reason, even though it was a hasty decision, it was a decision he made and he acted on it. That's all we've got to prove. It was all done with malice. All of that's correct. And the premeditation that he took on himself, he says, we have proved premeditation. Then he goes on to say, an intentional doing a wrongful act without legal excuse or justification, he goes to the notion of intoxication, which is an affirmative defense. That burden does fall on the defendant. The premeditation has to be proved by the government, but the avoidance of premeditation by intoxication is an affirmative defense that has to be proved by the defendant. I think if you read the whole thing and not just the one thing, he did not change the burden of proof on premeditation.
Your Honor, if you read the whole thing.
I just
yes,
read the whole thing. I'll read further if you wish.
I don't think that's the only thing he said about that. What Your Honor
He
quoted.
said, "We have undertaken to prove premeditation and have." And he went through several times talking about how he proved premeditation. But I'm quoting from the language right before he said that the defendant has to prove avoidance of that by intoxication. And so the lead up to that statement, if you take it out of context, it looks like it shifts the burden. But what he really does, he says, I do have the burden as the state to prove premeditation, and he can avoid it by showing intoxication. That's an accurate statement of the law.
It's not clear to me that in Virginia, under state law, and whether intoxication is an affirmative defense, because it seems to me, well, the district court and the...
I know the district court assumed the first error, but it seems to me this also goes to prejudice, because if he didn't misstate the law, there's no prejudice.
Yeah, correct, Your Honor, but just as before, just because at some point he states the law correctly, doesn't mean it wasn't
He states the law and the facts, and he says, I have undertaken to do it and have done it. And he uses the word premeditation, which is the only thing that the intoxication can undermine under Virginia law. In other words, premeditated...
That's not true. Your Honor, that's not true, because malice, if you read the court's malice instructions, it had, right in the record...
He said he proved malice, too.
He said it
done with malice.
Yes, Your Honor, but
And
that's
he laid
not...
out the facts.
He said he did, but he didn't prove malice.
Well, that's for the jury to decide, but my question is whether he shifted the burden improperly, and I'm suggesting to you, if you read it in context of what he said, just a very previous sentences, he stated the law accurately and as instructed by the court.
Well, that may be, Your Honor, but I don't see that makes a difference, because the government, I mean, there's no dispute that he was incredibly intoxicated. That's not a disputable issue. So, of course, he proved intoxication, and that negated malice, because he was...
Your challenge is that when the prosecutor said he had to show intoxication, the prosecutor was shifting the burden. And I'm suggesting to you he did not shift the burden on the elements of the crime. The elements of the crime required premeditation and for first-degree murder. And he said that was my burden, and I undertook it, and I satisfied it. And then he said to avoid that, the burden, he has to demonstrate.
I understand what you're saying, Judge, but remember, just remember that both the district court judge and the defense attorney himself, in his affidavit, states that he repeatedly shifted the burden to the defendant, that it was improper, and the defendant and the defense counsel's, the defense counsel was the one who admitted that he satisfied the first prong of Strickland. By failing to object to the repeated shifting of the burden of proof, the defense counsel, was at fault by not objecting and not asking for, well, we didn't even get into that, but I argue that another thing he could have done is ask for rebuttal, because he never really had any opportunity to rebut them.
When you go back and sit down, how about see if you can take a look at Morgan v. Commonwealth and see whether or not that helps you out as to voluntary intoxication under Virginia law.
I'm sorry.
Morgan v. Commonwealth, 646 Southeast 2nd, 899 at 902. I don't think it's an affirmative.
I don't have that in front of you, but if you could repeat what, I'm sure I would agree with you, but I don't.
It stands for the proposition that it's not an affirmative defense unless you get to insanity. But take a look at it.
I'm sorry, Your Honor, I'm having trouble hearing you.
Oh, well, I don't talk about it enough anyway. But I'm suggesting to you that case, voluntary intoxication does not constitute an affirmative defense unless it produces insanity. And what it does is mitigate.
Well, I think that's the way the court instructed. The court said voluntary intoxication is not a defense to any crime that does not require premeditation.
The state court said that?
That's what's in instruction 21.
It's not, but it is a defense to malice. I thought that was,
Well,
because
this was
if
the
you,
instruction given, and the instruction seems to be consistent with the notion that premeditation requires this thinking and undertaking a plan, and that if you're too intoxicated to do that, then it's second-degree murder.
well, the district court's, the state court's instruction on malice is very clear, and it's lengthy.
Well, I was talking about premeditation.
Oh, yeah.
I'm not addressing, because the part you're complaining about was the prosecutor was saying that premeditation belongs with the state, has to prove that, but that can be avoided by showing intoxication, and that the defendant didn't show it. And that's, I was addressing that and not malice, although the prosecutor included the word malice too.
Yes. I think one very significant way in which the State Defense Counsel, Mr. Light, fell well below the Strickland standard is Frizzell had a great defense to the malice element of all of these offenses beyond voluntary manslaughter, but he really didn't. He barely discussed the malice issue, and I don't know how anybody could say that Frizzell had a mind subject to reason at the time this happened.
Well, that's a question for the jury. The question, your complaint was that he shifted the burden improperly. I think the Lawler is the recent burden of proof on intoxication, and says, we have said, this is a state court, we have said a person who voluntarily has become so intoxicated as to be unable to deliberate and premeditate cannot commit any class of murder that is defined as willful, deliberate, and premeditated killing. However, proof of mere intoxication is insufficient. However, proof of mere intoxication is insufficient. The defendant must establish intoxication so great it rendered him incapable of premeditation. And it cites cases.
Yeah, but that instruction actually goes to
No,
not
I'm
just
reading from the Supreme Court case of Virginia. That was the Supreme Court from Lawler.
I'm sorry, I'm not. I don't have that in front of me, and I can't address that, Your Honor. But I can address what the state court judge said, and by the way, our argument isn't limited to although it does focus on the shifting of the burden of proof. We also challenge the other aspects of the trial counsel's effectiveness. Why
don't you take this up on rebuttal? I think we've gone
Yeah,
several
we
minutes,
have,
several minutes beyond.
You've
We'll
been
give you some-
generous to me, yes. Yeah.
We'll give you several more.
I'm past my rebuttal time, but I would appreciate.
Oh, we'll give you a rebuttal. We'll
Okay.
give you your rebuttal.
Thank you very much. Thank you very much.
All right, Mr. Curry.
Good morning, and may it please the court, Your Honors. Liam Curry on behalf of the appellee and respondent in this matter. Just to begin with just a bit of a roadmap, I know that the procedural posture of this case is a little bit unusual, but I think there was, from my opposing counsel's argument, a little bit of a conflation of what the exact posture of the two issues is. In the district court, on the issue of the permissive inference, the district court found that matter was not substantial for the purposes of Martinez and therefore was procedurally defaulted. I know the court didn't really have any didn't have a whole lot of questions for my colleague on that question. So if it's okay with the court, I'm happy to move on to the second issue, which is the issue that the court found was not procedurally defaulted, was substantial for the purposes of warranting a merits review in the district court, but ultimately concluded that while a reasonable counsel should have objected to the prosecutor's remarks in an attempt to get a curative instruction from the court, that ultimately there was no prejudice. And I think that the district court's finding of no prejudice finds ample support in the record, which includes the fact that the jury was properly instructed on this issue, both before argument, after argument, and that it received
What was after argument? Tell me what happened after argument.
Well, we have the statement from the trial judge where he's discharging the jury, stating that, that the case must be decided on the law as instructed. And I know there's been a suggestion that somehow this matter was decided without the jury having the written instructions. And I think the record plainly shows that that's not the case.
Why didn't the prosecutor, in his statements, actually follow how the jury was instructed?
Why? Well, I mean,
that goes, while you treat that as a first prong, it goes to prejudice too. I mean, the notion that if he correctly states the law, there's going to be no prejudice for what he said.
I believe so, yes. I mean, obviously, I'm not attempting to relitigate the performance prong. Obviously, the degree of fault in which the prosecutor's remarks could have been interpreted is certainly relevant for prejudice. And I would suggest that, the arguments in this record included, I think, approximately 70 transcript pages, and the number of objectionable lines of transcript is about somewhere between 15 and 20 pages. And subsequent to the objected to remarks, the prosecutor, Judge Niemeyer, you read extensively from the record, but there's at one point the prosecutor in the district court relied on this language. He just affirmatively states, let me make sure I have the right page in the appendix. That's on page 115. We have to prove that this defendant intended to kill. So there may have been some loose language from the prosecutor, but I don't think...
Well, in the section I quoted, he not only said we had to show he intended to kill, but he had to have premeditation.
Premeditation, that's correct, Your Honor. And
use that word.
Yes, and I don't think that there's any question, when we talk about prejudice and we want to look at the cases that have been cited.
I don't understand how you're acknowledging that the jury was prejudiced, could be prejudiced if the prosecutor stated the correct statement of Virginia law.
Well, I think I'm just trying to address it because it's my understanding that that's the opposing counsel's argument, that these, having stated, the language too loosely or in a way that suggested a burden shifting even one time resulted in prejudice. Obviously, I reject that position.
Well, it wasn't one time, it was 3 times, wasn't it?
It's a one incident for the permissive inference, if we're going to be precise about what language we're talking about. And then I think there was 3 distinct.
So where do we rein in a prosecutor who makes an argument like that where, the evidence was that he was at an alcohol blackout, he urinated on himself, he missed the guy 5 times, I mean, obviously he was drunk. Where do we draw that line?
Well, I mean, obviously we want the prosecutor's language to be precise and as accurate as possible every time he speaks on what the law is. But I don't think that this is a case similar to those that have been cited by my opposing counsel, in which the prosecutor urged the jury to consider an inaccurate or erroneous statement of law. This is not a case in which the prosecutor, there's several cases that were cited by my opposing counsel about the prosecutor had argued facts that were not in evidence, had blatantly misstated the evidence, and then materially relied on misstatements of the evidence at trial to, ask for a conviction on an improper basis. In this case, what we have is a jury that was properly instructed. We have a theory. We have there's approximately, the opening salvo of the Commonwealth's closing is essentially asking the jury repeatedly to pay attention to what each instruction of the law is and asking them to apply it correctly in this case. I think and then even in the, then there's multiple instances in the record where the prosecutor says, we know what our burden of proof is. At one point, there's a statement, he says, this is not a complicated case. We have to prove the intent issue. It lies with us. And we have done that. We did that in our opening. We've done that in our rebuttal.
Well, it's like I told your colleague, I mean, the intent issue, at least with me, is not a winning issue, even though it's the intoxication issue that bothers me.
Okay.
And am I right that obviously voluntary intoxication in Virginia is not an affirmative defense to any crime, but may negate deliberation and premeditation in a first-degree and capital murder case? Is that the law in Virginia?
That is correct. And I didn't raise an argument about whether it was an affirmative defense.
But do you agree that there's more than a scintilla of evidence about voluntary intoxication in this case?
I believe that there's only a scintilla, or there's certainly evidence of mere intoxication, which is not enough. And what I would suggest is that any evidence that could be interpreted as a level of intoxication that rendered Mr. Frizzell or Mr. Frizzell, I'll trust my opposing counsel's pronunciation on that. That there was insufficient or practically no evidence that he was so intoxicated that he was incapable of premeditation and deliberation, for the reasons that the prosecutor focused on. The entire purpose of the closing argument and the rebuttal is to show the jury that the evidence of premeditation and deliberation was pretty overwhelming in this case. I mean, we have the fact that, after he has been tased by the officer, he identifies the officer by name. He shouts at him in an angry fashion. He uses offensive language, and he does so not, while he's just leaning up against a tree, hanging out, minding his own business. The testimony is that his hand is in his pocket, and we know that in his pocket is a loaded revolver, right? So
He also says, which indicates his intent, you have screwed up, or used with a F word.
Yes, I'll clean it up and say you done messed up now, and I think that's pretty clear.
Well, that's sort of indicative of that he is now reacting to that observation, which is a premeditation.
That's correct, and I think what the prosecutor was probably attempting to do was to say, look, when we have gone through the evidence of the premeditation and deliberation, it's going to be really hard for a jury to conclude that he is not premeditating based on the facts that we are focusing on in our closing argument. So therefore, we have necessarily also proven that he can, in fact, premeditate, that while he is intoxicated, while he has marijuana in his system, while he has been tased, the facts that necessarily show that he did premeditate also show that it is not a reasonable conclusion to conclude that he was incapable of doing so. And so I think that's, and then, so I think,
Go back to this defense. The element of first-degree murder includes premeditation, right?
that's correct.
And as distinct from all other crimes where intoxication is not a defense, the Virginia courts have said that. They have said it is a defense to premeditation.
That's correct.
And it says here, defendant must, this is the Lawler, defendant must establish intoxication so great it rendered him incapable of premeditation. Here's the Essex case. the defendant may negate the specific intent requisite for capital or first-degree murder by showing that he was greatly intoxicated as to be incapable of deliberation or premeditation. Geronimo, this is another one. The defendant's level, oh, that's just a fact finder must find, but it's the same type of thing. But they all put the burden, after the government proves premeditation, put the burden on the defendant of showing that he was so intoxicated he couldn't premeditate. And whether you call it an affirmative defense or an avoidance, it seems to me the government satisfies its proof by evidence of premeditation and recognizing it had to prove premeditation. And when it says then the defendant has to show intoxication, these cases say that explicitly. 3 Supreme Court cases from Virginia, and I don't know why there's such a big debate over whether the jury was improperly informed.
Well, I mean, based on those recitations of the law, it's clear that the prosecutor's arguments were accurate statements of the law. But, that was not a position that I had adopted in the district court, so I didn't.
Well, I understand. You're focusing on the prejudice, and you said there's plenty of evidence to show that regardless who had the burden.
Right, but it certainly is, it is still relevant for the prejudice question.
Of course, the government's evidence, they did put in evidence of intoxication, but the government also put in evidence of premeditation with the delay in the use of the gun, the reflection on it, the statement he made to him. He was intoxicated. As Judge Floyd said, he fired 5 shots, and I think he missed completely.
Sure, but the testimony was not only that he fired 5 shots, is that this is not a situation in which he removes the gun from his pocket and it goes off, and that's a similar factual scenario.
No, the evidence suggests some deliberateness in pulling the gun out. That's no question about it.
Deliberateness in pulling the gun out and in pointing it in the direction of the officer. And there's testimony that the weapon that was fired was one that needed 5 individual trigger pulls, each capable of showing more and more additional evidence of specific deliberation and Mr. Frizzell's specific intent to kill this officer in this instance.
Anything more?
I don't think there's anything more unless the court wishes for me to address the Fisher cumulative prejudice argument. It was the position in the district court that there was only one non-defaulted claim, so cumulative prejudice review was impossible. If this court were compelled to find that both matters were substantial for the purpose of Martinez, I would ask this court to find under Fisher that cumulative prejudice review is not the accepted practice of the Fourth Circuit.
So you say, that, and I'm not excited about the intent issue. Suppose the panel majority says the intent is substantial. You don't believe that these procedurally defaulted claims can be aggregated?
If it's procedurally defaulted?
Yes.
No, I don't think so, because effectively then that, I think that would spell the end for procedural default if the court would still be required to review. Well, it's like, let's just pretend this wasn't defaulted and see what the prejudicial effect of these errors might have been. It would only be possible if both claims were substantial for the purpose of Martinez, but then that's when I would suggest that Mr. Frizzell would run into the problem of Fisher, which has held, and subsequent cases have held in this court, that cumulative prejudice review is not permitted in this court. And I would just submit any remaining issues and questions to my brief and ask this court to affirm the judgment below. Thank you.
Mr. Smith?
I want to quickly address several points here, specifically on the premeditation point that Judge Niemeyer has been focused on. It wasn't just that the prosecutor allegedly shifted the burden of proof improperly to the defendant on that
The
point.
burden of proving what?
Proving intoxication. Your Honor, let me finish.
No, but it's very important because
Well, it's
your
not just
argument depends on shifting the burden of an element of the offense. And that can't be done under the Constitution, due process clause. And one of the elements is premeditation.
I understand.
So your argument has to be that there was a shifting of the burden of premeditation.
Well, that's the main-
intoxication, the absence of premeditation, you can't prove the absence of premeditation, the burden on the government by intoxication.
Your Honor, one of my points is we never raised a sufficiency issue in this case. There is no sufficiency
No,
issue.
you raised a shifting burden, but my question is, what was shifted? And you say the government had the burden to prove the absence of intoxication as an element of the offense?
You know, I'm not, after hearing Your Honor recite what various the Virginia courts have said, I'm not sure about that at all.
Well, I'm not sure either. I mean, it's
Okay.
just not totally clear because
I just
it
want to
may
make
not
it
be
different.
affirmative defense like insanity is, but it is a burden that he carries because it doesn't make sense to put the burden on the government to say he wasn't intoxicated.
I understand, Your Honor, but it's clear, you know, my point is this. It's very clear, there's overwhelming evidence, contrary to the government, that he was intoxicated. It's all in my briefs. Just read that again. But here's the more important point that I want to make, Your Honor. Wasn't the prosecutor also distorted the burden? Let's assume that the defendant does have the burden. He certainly didn't have the burden to prove that he didn't even know what he was doing. That's more like an insanity defense. There's no case law saying that is what the defendant must prove in order to show intoxication, which negates malice and premeditation. So look at what the prosecutor kept arguing was the defendant's burden. Not merely that it's the defendant's burden to prove intoxication. He was arguing, which he could have been correct on, as Judge Niemeyer says.
Yeah, he has to prove mere intoxication is not enough.
Well-
He has to prove that he was so intoxicated that he could not premeditate.
Yeah, but that's not what he said. He said he has to prove that he didn't even know what he was doing, which is really, I argued this in
You
my
think
brief.
that's
That
different
sounds
from-
like an insanity defense, which is a much higher level of proof necessary to prove insanity, which is the defendant's burden. And that was never
Like
corrected.
Essex says, the defendant may negate the specific intent requisite for capital or first-degree murder by showing that he was so greatly intoxicated as to be incapable of deliberation or meditation.
I don't.
So that's a higher level than just
Oh,
intoxication.
yeah, I'm not disputing that, Your Honor. What I'm saying is that what the prosecutor insisted the Mr. Frizzell had to prove was a much higher level than that you just quoted. He said he has to prove he doesn't even know what he was doing at the time. In other words, he thought he was at a.
So you think that's different from the inability to deliberate or premeditate?
Absolutely different, way higher burden. He's saying the defendant had to think he was at a carnival shooting at, in one of those shooting games, you knock down the ducks at, instead of where he was shooting at the deputy sheriff. That is completely wrong. The defense counsel never objected to that, and it was never there was no curative instruction. The state judge didn't stop the prosecutor and say, wait a second, that's not his burden. I mean, he could have said, yes, he has the burden of proving intoxication, but he doesn't have to show that he didn't even know what he was doing. And just look at that's not the only instruction that the judge gave. Look at his malice instruction, which is correct and not disputed. The malice instruction itself shows that the government had an incredibly weak case on malice, which malice is necessary for any murder offense in Virginia.
We have before us really only the two prosecutors' statements. That's what we have agreed to review on this case. Anyway, I think I'll give you 1 minute to wrap up. How's
Okay,
that?
yeah, thank you.
You're over
I
through the
really
red light.
appreciate that. You know, one thing I couldn't get to, given the time limits, is that, you know, the government's basic argument throughout in its response brief is that the evidence was overwhelming. The government's evidence, the state's evidence was overwhelming. It clearly wasn't, and I spend most of my reply brief, which is lengthy, shooting down that argument, and you've got to read that because that's really what this case should turn on. And it's very important to note that the judge, the district court judge, never said or even suggested that the government's evidence was overwhelming, because what I'm arguing is that the real issue here is whether the district judge was correct to say there was no prejudice from what happened. And this is a case where the government's evidence on the mens rea elements was weak, and certainly the intoxication evidence was incredibly strong. I mean, again, just look at the briefs. You don't have to dig through the record to find this. It's right in my briefs. I mean, and the district court recognized that. Read the district court's opinion. Where he talks about.
We've gone far beyond. We understand your arguments.
Okay, you're I really do appreciate
thank
it.
you very
This could be my, you know, I'm going to be 75 later this week. This could be my last argument before this court. So.
Well, no, we'll see you back. You got many years to go.
I hope you do. I really intend to keep going as long as I'm able.
Well, congratulations on your achievements.
thank you
to
so
practice
much, Your
that long it's a noble practice, and
Yeah.
you obviously value that.
Well, I really appreciate your words, Your Honor. Let me just mention one thing that's not in the record. Mr. Frizzell has already served 8 years and 9 months, exactly, 8 years and 9 months in state prison. He's not in good health. He is, you know, he's 61 years old, 61. So I ask, take that into consideration if you're thinking about. I'm not saying that should sway the judgment of the court, but if you do agree to vacate the decision, I would suggest that you try to avoid sending it back for an evidentiary hearing, or unless it's really necessary, because his wife is afraid he's not going to last many more years if he's in prison. So take that into consideration.
We'll come down and we'll greet counsel, greet you, and
Thank you.
and then take a short recess.
Thank you.
This honorable court will take a brief recess. The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
All right, be seated, please. Next case we're going to hear is Appalachian Power Company versus FERC, and I guess we'll hear from Mr. Kaiser first.
Thank you, Your Honor, and I've reserved 5 minutes for rebuttal. May it please the Court. William Kaiser on behalf of the petitioner. This is a contract case. The question before this Court is whether FERC's interpretation of 3 full requirement energy service contracts to allow the use of battery storage to reduce end-use customers' energy consumption violates the terms and conditions of those contracts and therefore is arbitrary and capricious. We believe it is. In reaching its decision, FERC ignores how the batteries will be used and how that is contrary to the symmetry that a full requirements electric service contract requires. So I'm going to talk about the contracts. There's 3 contracts at issue here. I'm going to focus on the Radford contract, which starts at JA 87. For purposes of the discussion, the contracts are virtually identical. There are a couple of minor differences. If you ask questions about them, I can point them out. But I just feel as we're going to be focusing on the contracts, it's easier to walk through the record and focus on one particular contract.
Well, the Virginia Tech contract clearly has that language in it. Where's that language in those other contracts about?
The Virginia Tech contract explicitly identifies battery storage as existing generation. The other contracts don't discuss battery storage explicitly, but that doesn't mean that the contracts themselves don't contemplate the behavior that the battery storage allows and prohibits it under the terms of the contract.
And doesn't this dispute turn on the term generation?
I would argue that in FERC's mind it does. I would argue that it doesn't. So I would argue that even if you agree with FERC, which we disagree with, and we can talk about that, but the terms of the contract itself still disallow the use of batteries in the way that the customers plan to do so. And I can walk you through the contract and explain that to you.
Following up a little bit on Judge Floyd's question, it seems to me, and you can tell me if I'm wrong, is it prohibits it from the customer from using constructed or purchased generation resources, right? Is that the language?
That's in 3.1C, right? At no time, customers shall use newly constructed generation resources or purchase generation resources or new power purchase agreements.
That's the prohibition that you have to rely on or interpret. That's what FERC relied on.
That's what FERC relied on, but I would argue that FERC ignored other provisions of the contract that are.
Well, your arguments on the others are the consequences to go to what the intent of that is, but I'd like to focus just on those words. And I can tell you the process I went through, and then you can tell me whether this is right or wrong. The FERC opinion treats the batteries as storage. Which doesn't mean new generation. It means storing existing, which might seem to be in favor of FERC's interpretation, if that's so. So I started considering what a battery is, and I won't tell you the whole process I went through, but it seemed to me that in this case, the battery is filled, so to speak, charged by Appalachian Power electricity, and the battery is discharged on the customer's line. The difference is that the battery is charged during off hours, and then it is discharged during peak hours.
Correct.
And so it lowers the peak. So it has the consequence of affecting the allocation of costs and your plant, which I understand fully in your argument. But this prohibition doesn't seem to prohibit a storage facility as distinct from a generating facility. In other words, this is a little bit like catching the rain in a bucket catching water in a bucket during the rainstorm and saving it for the dry period. So the electricity is stored in the battery by charging it during off hours, and then it is discharged during peak hours. Now, it would seem to me that that would not, in that context, prohibit the conclusion reached by by FERC that this was a storage facility, and a storage facility is not a generating facility. Now, your argument is that that changes the allocation of your plant because it's designed for peak hours, and that's the allocation of costs. And it might be that you could argue on that issue that you could impute peak hours without the battery to try to generate some allocation of costs. But that was not decided by FERC and is left open explicitly, the allocation of costs. The only question is whether the battery itself is prohibited. And to determine that, I looked at that clause, newly constructed or purchased generation resources. And FERC concluded that that does not prohibit batteries because it's not new generating resources. It's using Appalachian's power to charge, refill it, and then discharge during peak. That's where I sort of looked at this, and I'm happy to have you correct anything because I'm not locked into anything.
Sure, and let me, there's a lot there, so if I kind of go in pieces here. I think one thing that we have to focus on is a timing aspect here. And so I think you focused on that in your question because as you pointed out, when the batteries are used, right, they're going to be charging the batteries at off time and using them during peak time.
And it's going to end up reducing your ability to recover those costs.
And the capital investment made by the company in order to serve.
There's no question about that. So my whole point is the prohibition that FERC relied on is generation resources, but they explicitly left open the allocation issue. And it seems to me you could make a very powerful argument to FERC that if a customer uses a battery, we're now going to impute usage at the peak time without the batteries in order to allocate costs. That's a good argument you could make because what they are doing is reducing the peak levels, which reduces your ability to demand cost allocation.
Sure. So two things. Let me get to your second point first, because the other argument we did make at FERC is in addition to the allocation for these customers and being able to change that under the agreement, there's also the concern about cost causation and the fact that the way that this works is that when they shave their peak, and I think there's some evidence in the record, it's in the rehearing, that it's going to reduce and these are estimates because we don't quite know how they're going to use them.
I think you make a very persuasive argument. The effect, it's going to reduce the peaks. And as a matter of fact, that's the intent of the battery.
Correct.
To reduce the peaks. And it's conservation of energy. So you're affected because it reduces your ability to recover plant costs and so forth. But again, isn't that just an allocation and not whether battery is prohibited?
Well, I want to turn you to 3.1a because I think that's an important provision to focus on because it informs what's going on in 3.1c, which we're talking about. So when we're talking about 3.1a, that says during the delivery period, customer shall sell, or company shall sell, and its customer, in this case the city, shall exclusively receive and purchase full requirements of electric service sufficient to serve customers' retail load. So that creates an obligation on behalf of the company. They have to sell and deliver, and on the customer, they have to receive and purchase two things: full requirement electric service sufficient to serve retail load. And so when you look at the definition, and these are important for this determination of full requirements electric service, that's the supply of firm energy. So now we're talking about energy, not just generation, to be provided by the company to the city as may fluctuate in real time. So that's focusing.
They did purchase it from APCO, from Appalachian Power, during off hours and stored it in a battery and then took theoretically the Appalachian Power at the energy that's in the battery and distributed during peak hours. So it was a timing issue. It's not a new source issue. And it's full resources because they still used Appalachian Power completely, energy. The problem for you, and I think it's a legitimate problem, is it adjusts your cost structure which still should be addressed. But I don't know if you can blur the two.
Well, and I would say, as I mentioned, right, the full requirements electric service is talking about the energy supplied in real time to serve the customer's retail load. And when we're talking about retail load, we're talking about end-use customers here, right? So the definition of retail load is energy to supply the city's end-use customer, not the city, who's taking that power to be stored in the battery, but the end-use
The whole point
customers.
is, I understand that, but they're still using Appalachian power. You're suggesting that at the peak time, they're not using all Appalachian power, they're using battery power too. But the battery power is stored Appalachian power.
Right. It is stored Appalachian power.
It's a timing issue which affects the cost.
It is a timing issue, and that's important, right, for the many reasons you just talked about. So it's a timing issue that's laid out in 3.1a, because what 3.1a requires is the company to sell and the buyer to exclusively receive and purchase from Appalachian Power the power necessary to serve their end-use customers in real time. So when they're substituting the battery in there to use that, even though they took that battery ahead of time, took that power ahead of time, they're still using that power to serve their customers. So that's...
Yeah, but that power is deferred Appalachian power.
Right, but it's the time when that power is used, and 3.1a is important here because it establishes that symmetry, which I talked about, which lines up what Appalachian Power must do, which is provide all the power necessary to serve the end-use customers at the time of their peak need. So if the cities are using the batteries to supply those end-use customers, then they're at the time, in real time, they're not taking that power from Appalachian Power. And that's important. No, because
They're taking it from the battery, but it's Appalachian Power's energy.
Right, but the importance here is going back to why that provision is important and why that timing provision is important.
It's very important for the allocation of costs.
Correct.
But it may not be important for determining whether it is an independent generating force or is part of Appalachian's. It's a full requirements contract. All the power that the customer's going to use has to come from Appalachian Power.
Right.
Okay, so Appalachian Power supplied all the energy that's going to be used. What they have done is they've managed that energy with a battery by charging it during off hours and discharging it. They're delayed the use of that energy. And so the way FERC addressed this is they call that storage. And that took me back for a while because I know when I turn on my flashlight is producing energy to light up the thing. But that only takes into account the discharge of the battery. And of course, the charge of the battery came from APCO's energy. What you're saying is that your rates and your facilities costs are determined on a timing issue.
Correct.
And the full needs at the peak, which should not include the battery.
Right.
Even though the battery is Appalachian Power battery. And I would think as FERC sitting here, they should sit there and stand up here and say, you get some allocated costs.
Well, they didn't do that.
Although this has not been, you get to spread those costs among the customers and maybe on some imputed basis. But the long and short of it is it's leveling out the peaks with managing Appalachian Power's power.
That's exactly what they want to do, and I mean they're explicit about it. They talk about it in their petition to the commission, and so this isn't a question. Absolutely, and I'm going to keep coming back to 3.1a because I think it's important because it sets up that timing aspect, which is important because as you said. So let's go back to the timing aspect. It sets up the timing aspect that Appalachian Power has to be providing the power necessary to serve end-use customers in real time. And when they're using the battery to do that, they're taking that away. The city itself, which has taken that power at one point and is using that power at a different time, is the one serving at that point, right? It's already taking the power. And why that is important is because, as you talked about, when we start talking about the compensation, the recovery for capital investment, when it comes to the demand charge, which is the charge for fixed capital costs, Appalachian Power has to determine ahead of time how much power the end-use customers are going to need. Because in the summertime in Radford, when all the college kids are back and all the air conditioners are going and, they're at their highest peak. The company has to plan for and make sure it has the generation resources in place to serve those end-use customers.
So hypothetically, if at 12, no, let's say 8 o'clock in the morning, I don't know what the low demand time is, but let's say 8 o'clock in the morning, the customer buys all its needs, 100% of its needs. Mm-hmm. And then over the period of the days, it disperses it. And the next morning, then it buys all its needs. You're saying you're not designed for that because, number one, you couldn't produce all the power at one time. You have to produce it over a period of time. And that power demands are low in one part of the day and high in another part of the day, and therefore a requirements contract has to be geared to the timing of the availability of power.
That's right.
But the question is whether a battery is prohibited, and I thought you relied on the generation resources, and that's what FERC relied on. That clause, what's it, C? 31C.
31C.
31C, and you're going to 31A, and my question is there something in 31A that it tells the purpose, but does it prohibit the customer from leveling out the peak?
So it says during the delivery period, and the point that I didn't get to on 31A, which I should have emphasized, and my time is up if I can
go ahead.
Finish. Right, so and that's my fault, I left off. So during the delivery period, companies shall sell and customers shall exclusively receive and purchase full requirements electric service sufficient to serve customers' retail load except as provided herein. And here, there is no sort of demand response or no demand management type of provision in here that would allow that to happen. So what we're saying is that the use of the batteries in the way that the cities are trying to do is what violates this 31AC. I would also argue we disagree with FERC's determination that batteries are not generation.
That's where it gets back to my point, because the battery generates when it discharges, but it degenerates. It's the opposite when it's being charged. And so the argument that FERC makes, or the ruling that FERC makes, is basically that amounts to a storage facility because it is using Appalachian power energy to charge it, and then it's using that power and discharging it during peak hours when it's a timing issue.
Sure.
And it does lower the peak, and it does change your cost allocation and collection of rates. But it's an interesting case, and I'm not sure. I guess our standard of review is we interpret contracts as a matter of law, so we look at it de novo, I suppose.
That's what we would argue, yes, Your Honor.
Would we give FERC any credit for the fact that, with respect to discussing power and whether a battery is storage, that is more of an expertise type of thing, or would we just treat it de novo?
I think FERC would argue you should treat it de novo, but I would argue no, because you're looking at the terms of the contract here, and that's what you're interpreting. And I would also point you to, I'm sorry, I'm well over, but let me finish this thought. I would also point you to the way that FERC looked at generation here. It looked at the dictionary generation. To me, that doesn't really show any kind of additional kind of expertise beyond what's in the...
Generation sort of means producing, and I think the aspect of the battery when it lights a flashlight is producing energy. There's no question about it. But the real question is when the battery is used online, as opposed to being, if the battery were charged by a solar cell or by the stream in the back of the plant, now you have generation because the source is not Appalachian power. But in this case, according to FERC, the source of the generation was Appalachian power, and then the discharge, it was delayed. Anyway, you understand what my thinking was and concern was, and it's a fairly complex arrangement here. You guys can't go out of business, but you got to help us save electricity.
Well, that and I, again, I'm well over, but there is a cost causation issue here that FERC didn't address that we raised as a concern below as well. We're talking about other customers.
Open, and you may still be able to raise that, I think. I think you should, when you get out of here, but lunchtime, go file a petition on the cost allocation.
Thank you, Your Honor.
All right. we'll hear from Ms. Banta.
Good morning. May it please the court. I'm Carol Banta for the commission. There's a lot I want to pick up from the topside argument.
The question is, have you already offered them a little bit of adjustment on their plant allocation?
Well, no, but let me explain why. Because I do think that's a creative idea, and they should perhaps propose that when they're renegotiating this contract, which expires in 2026. I can't offer that, and I don't think the commission could either, because they didn't bargain for it in this contract. It's not in this contract. And if the
Well, their argument on the contract is that the whole contract is designed on real-time consumption of electricity.
Well, but it doesn't.
And it changes, and that is a graph. And this changes the peak on which its cost allocations are dependent.
Well, and the problem for petitioner, and I do want to get to the ways that they could still seek what you're discussing. The reason I can't offer it, and I don't think the commission could have in this proceeding, is
I
if they
wasn't
didn't-
seriously requesting
No.
you offer it.
Right.
I thought, it seemed to me that there doesn't need to be hostility between the parties. There ought to be accommodation, it seems to me.
Well, and they certainly could attempt to renegotiate with these customers. They could attempt to renegotiate this contract, but again, it does expire in a couple of years, and there will have to be, if they're going to continue service at all, some new contract that they can negotiate. They can negotiate the Virginia Tech language. They can negotiate something like what you're suggesting. But on the terms of this contract, the commission said you have the freedom to make a bad bargain or a bargain that you're not happy with, but that doesn't mean we have the ability to
Well, I
read
think it
terms
was
into the contract.
I think it was unforeseen, at least, not totally, because the Virginia Tech contract has the battery language.
And battery storage by 2017 was being used for things like this. It was this isn't a 20-year-old contract where no one could have known. Oh, and I do want to address briefly, I don't want to jump around too much because I'll lose something, but.
I pulled you off track. Go ahead.
Oh, no, because I do want to discuss your concept of batteries a little bit, but going back to the point about what they negotiated and interpreting the contract that they negotiated, these were sophisticated players. That doesn't necessarily mean that they're both happy with the terms of the contract, but the Morgan Stanley decision from the Supreme Court says that when sophisticated parties negotiate an arm's length contract like this, it is presumptively just and reasonable, and it will be treated as such unless and until it is shown not to be just and reasonable. They could bring a complaint proceeding saying this contract is not just and reasonable and must be reformed under the Federal Power Act. That wasn't this proceeding. This was just interpret the contract, a declaratory order interpreting the contract as it is. Now, it's true that were they to bring a complaint that the contract is not just and reasonable, there is a very high bar. Morgan Stanley talks about that, but the fact is that's a proceeding that exists. So it's not that there's no possible way to get yourself out of a contract that has become extremely unjust and unreasonable. Just that was never this case. This was interpret the contract on the terms that it is. And just a brief note on the standard of review, I do think the commission can be affirmed under any standard, but I would point out these are not just private commercial contracts. As I was saying, Morgan Stanley discusses these kinds of, they discuss contracts entered under market-based rate authority. But those are still contracts that exist by dint of FERC approval, even if the commission didn't specifically approve this contract. It approved the market-based rate authority without which this contract would not exist. So these are not simple private commercial contracts. They are contracts that have what I believe, if I've got the right case, was Cajun Electric referred to as a public interest gloss. And those are the kinds of contracts that deference to the commission, even when the expertise isn't brought to bear on the contract, although we think it was.
What's the principle for that?
The principle for that is,
It sounds to me like it's sort of a extended Chevron type of thing, which Chevron, of course, did statutes and regulations, and maybe an approved contract is regulatory. But I'm not sure I'm aware of Chevron being applied to contracts, but
Well, it has been, but
Of
this
course,
does not
Chevron's
depend.
gone, as you know.
Yeah, this does not depend on Chevron. As we discussed in our supplemental brief, it goes to cases that long predate Chevron, and the key ones from this court was the seminal case of Consolidated Gas, which was very influential on the DC circuit, in particular in National Fuel. And in National Fuel, which postdated Chevron, the DC circuit said, okay, Chevron has something to say about this, but there are reasons that we've been deferring and should be deferring on contracts that have nothing to do with Chevron. And it talked about, for one thing, there's an explicit delegate at 1569, page 1569 in the National Fuel decision. It talks about an explicit delegation to FERC as opposed to an implicit one as in Chevron. But it went on to talk about two particular reasons why deference to agency interpretation of contracts is appropriate. One was the expertise, but not just limited, again, to expertise where it's brought to bear on this contract, although in this case I would argue that it was, but that there's language in National Fuel, and it goes back citing cases like, I forget what they cited in National Fuel, that talked about the agency having expertise in this field of enterprise, just being familiar with these kinds of contracts because we see them all the time. But the second thing that National Fuel discussed was also that these contracts are special because they wouldn't exist without Federal Power Act authority. They aren't ordinary commercial contracts. They are, I don't have all the cases in my head, but they're all in our supplemental brief. We're talking about how these contracts have a public interest gloss to them, that they are almost like a commission order. They're elevated to something beyond ordinary private commercial contracting because they would not exist without FERC authority. And they are subject to...
Just getting more detailed, could Appalachian Power have gone into a federal court and sought a declaratory judgment?
Well, under the contract, I think their alternative was Virginia State Court. Now, could they get a declaratory order being essentially an advisory opinion on what the contract means before there's a breach? I don't know.
It would be over, they'd have to allege a legitimate dispute with the customer.
Yes.
But I'm assuming that, and I don't know if the standard for declaratory order from the
Right.
FERC is different from a state declaratory judgment, but my question is, could they have gone? I'm raising that simply to question how much your argument carries, because if they could do that as an alternative.
Well, let me tell you what might happen in that case. And I had a case which we cited in passing in the brief called Fairless in the DC Circuit, where there was an argument about a breach, and someone went to state court in that case, and the other party came to FERC with a request for declaratory order about what the contract meant, and the commission, as here, exercised its primary jurisdiction. Now, that's discretionary. It doesn't have to. Sometimes the commission can say, we don't see a need for us to speak to this. Go on with your state court action, because we do have concurrent jurisdiction. But in this case, as in Fairless, as in the North Carolina Eastern case that was the Duke Energy Progress case on appeal, the commission said, no, this is one where we think our expertise is involved and the other parameters of our own test for primary jurisdiction, like the need for uniformity and the importance to our regulatory responsibilities. We're taking primary jurisdiction. So what happened in that case is in Fairless, the Texas court, I believe, put the case in abeyance because the court was going to pay attention to what the commission said. So yes, there's concurrent jurisdiction to go to a state court or perhaps a federal court. But when the commission exercises its primary jurisdiction, it still matters. And the court is probably either going to defer to it or pay attention to what the outcome is. And that's what happened in the Fairless case. So
I still don't understand how the commission has any more expertise in interpreting the terms of a contract than the court does.
Well, because we see these full requirements service contracts all the time, and this is actually a recurring issue, the role of battery storage in full requirements contracts. We have this case in the North Carolina Eastern case. There's a more recent case that's still working its way through the commission that we recently issued an initial order on. So it's a kind of contract that we're familiar with because the dispute here doesn't entirely turn on the definition of generation. The commission actually looked at three different aspects here. It was the definition of generation. It was the exclusivity requirement that your sole provider be Appalachian and that you not make purchases.
Well, that's inherent in the prohibition. It says it prohibits external generation.
But it says it in several places, including 3.1A that Mr. Kaiser was pointing to. The customer shall exclusively receive and purchase. So the exclusivity was important, and that's where the commission went into the analysis of the fact that the batteries would be charged using Appalachian's power, not someone else's. And then
I would suggest, even under the generation clause, that if the battery were charged solarly, by solar or by some kind of stream flow, a windmill or something like this, that would be introducing a new generation of power, because you're converting either the whatever the source of the charge is. But here the charge was done by Appalachian
Power in, Appalachian Power out. And the only thing I wanted to say, I liked your rain bucket analogy earlier, except
it's
that
not totally perfect, but
the rain's coming entirely from Appalachian's filling the bucket. And that's the thing. The kind of batteries you have in your flashlight are a little different, but if you ever buy the rechargeable ones,
a flashlight would indicate the opposite. And your first indication is, your opinion used the word storage, and that took me back because I thought a battery generates electricity. It does. And you light a flashlight, and it produces the electricity to provide the light.
But think about if you buy rechargeable batteries for your
It's used here
flashlight.
in the system, in a stream where the charge comes in. And anyway, you understand what I was arguing with him.
The battery in your car. We're used to batteries not just being. I honestly don't know how your standard alkaline battery works, but a rechargeable battery, you plug it in, Appalachian Power fills it, and you put it in your flashlight. So it doesn't. And what you're talking about, like solar, wind, those are producing. This is very much dispensing. It's about dispensing.
If it were not rechargeable, then it's a chemical source.
It would be some kind of generator at that point.
Well, let's change the subject to the elephant in the room. You were supposed to apply Virginia law, and it appears you did not, but you did a post hoc rationalization about it. Can we buy that argument?
Let me, two answers to that. For one, we did not provide any rationale that the commission didn't. All the canons of construction that we discussed in our brief are cited in the order, but let me point to an important case which the petitioners actually cited. There's a Fifth Circuit case called Pennzoil that they cited that said that the commission has to apply state law and not general principles. What Pennzoil says, and let me give you two cites because there are two Pennzoil cases, and this is very important. 789 F. 2nd at 1142, and then the predecessor Pennzoil case at 645 F. 2nd at 387. What the Fifth Circuit said in that case is that the commission can assume that general contracting principles apply. And if there's a difference in the state law, you have to point it out. You cannot, the commission is fine with applying general principles of contract law unless you point out to them that state law is different. Well, they still haven't. There's nothing in Virginia law that there's any evidence in this, or not evidence, there's no briefing in this case that anything in Virginia law differs from the general canons of construction that the commission applied. So in our brief, when we did supply Virginia citations, they were only for rationale that the commission had already offered in its cases about you can make an improvident bargain, in its cases about Barnhart versus Peabody Coal, that's the United States Supreme Court. The canon expressio unius, et cetera, does not apply to every statutory list or grouping.
Well, I mean, is there any limiting principle to the notion that FERC can just interpret contracts within its jurisdiction under any law it chooses? I mean, is there,
well, it applied general canons of construction, and certainly.
Is that your limiting principle?
Well, yes, because if Virginia has a canon that differs from these, which we don't see any reason to think it does, because all the Virginia cases we've looked at, they're the same canons as applied here. But under the Pennzoil case that petitioners themselves cited, you have to say to the commission, hey, that's not what the principle is. Because Virginia has a different way of applying expressio unius, but it doesn't.
So that's the limiting principle. If there's some difference, they have to point it out to you.
Yes, and they didn't point it out to the commission, and they haven't pointed out to this court. They don't like the outcome of this, but they haven't pointed to any respect in which the Virginia canons of construction, and again, the cases from Virginia talk about expressio unius the same way.
Opinion is going to be written by this court, and we say, what you did here is fine. You just applied the general principles, and if it gets published, then, other courts are going to look at it. And so I guess my question is, do we have to draw a line or just let it ride?
I think the Fifth Circuit did it twice in the both Pennzoil cases, and it was pretty clear. And yeah, the commission deals with nationwide issues, and it is familiar with the general canons of contract construction, but certainly, and it's done this in a number of cases. In the Fairless case that I had, it would have been Texas law, but nobody pointed out that we got anything wrong under Texas law because the principles were the same. There's a different choice of law in any one of these contracts, but you have to tell the commission, hey, Virginia doesn't apply that one that way.
It sounds to me like it's a burden issue you're saying, but I would think that it could go both ways because the Appalachian could be relying on some general principle of contract law for its interpretation, and you could be saying, but that's not consistent with Virginia law.
Well, yeah, if we had reason to think that they were arguing something and they were wrong about, sure.
It depends on how it arises, but it seems to me either party could challenge. I mean, general contract principles are fairly
universal,
fairly understood. I mean, everybody, basically, you're going after the intent of the parties. It's a law binding the parties' arrangement. But
either party could say, yeah.
But I would think the principle you cited could be flipped, whereas you're objecting to their generalized interpretation of contract law because Virginia has an exception or more narrow application.
Right, and one of the parties
And
to...
you're saying in this case, nobody has raised it. Either side has raised a question of whether Virginia law is distinct from general contract law.
That's right. I mean, these were pretty well-established everywhere principles, like...
Let me make sure that you have time to respond to counsel's argument that a particular section of the contract requires the purchase of peak needs at the moment of the peak need.
Well, it does not. I mean, the commission said there's no provision for a minimum purchase or a minimum peak obligation. And the language, I think that they're pointing to, that he's pointing to...
They pointed to 3.1A.
Yeah, 3.1A. It says you shall exclusively receive and purchase, and we've addressed the exclusivity. And it says full requirements electric service. And so I believe my friend is pointing to the definition of full at 1.23. Now, I had tagged up the Craig Botetourt contract rather than Radford, so I'll give you JA 32 on that. Full requirements electric service means the supply of firm energy to be provided at the delivery points. So we're talking about the meters. So we're talking about the power being delivered to the meters, not what's going on with the batteries behind the meters. You're delivering to the meters to charge the batteries because the batteries are behind the meters. And it may fluctuate in real time to serve customers' retail load. And it may fluctuate in a number of ways, which the commission discussed in the order, including increased or decreased usage. Now here, it is more of a timing issue than a usage issue. We do have what amounts to decreased usage, but it really is, I think we all agree, a timing issue because the Appalachian power is going into the battery and nothing is coming from the battery that didn't go into it from Appalachian power. So there's nothing in here that prescribes the timing. The commission didn't see it that way. I'm not sure it was even, never mind. But, and if we go from full electric requirement service to at 1.23, and we go to the next page to look at retail load at 1.45. And again, we're talking about metered at the delivery points. And it's to meet the requirements of the customer, because here the customer is the city or the cooperative. It's not the end users. It serves those end users. But to meet the requirements, it doesn't say when. It doesn't say it has to all be at once. So that timing thing wasn't here. And again, the commission pointed out in footnote 55 on JA 363 in the order, the Virginia Tech Agreement, which granted comes later, shows that you can bargain for language to cover that. You can bargain for language to address a timing issue. And they didn't in this contract, and they're sorry that they didn't. And I'm sure they'll try to include something like that next time when they negotiate it. But the commission, again, applying general contracts of canons of construction, is not going to put words in that aren't there because one party wishes that they had included them. And we cited the cases for that in our brief. We can't read it in just because they're sorry it's not there. It's not there. Virginia Tech agreement shows that it could be there. If you want to put it there, you can negotiate for that language and get it.
What was the chronology of the agreement? Is the Virginia Tech the first agreement?
The last. It is the last. It is, the first three agreements are all within a 2 or 3 month period in 2017. And the Virginia Tech agreement is 18 to 20 months after those. 20 months after the first ones and 18 months after the last one.
Well, it appears they figured it out.
It does appear that they learned some lesson that they wish they had known.
They allowed battery, didn't for Virginia Tech?
With a hard cap and a limit on when it could be, the timing issue. Yeah. The timing issue.
Well,
Not just.
I would think that may become, or they could even do some other aspect so that they're participating in the lowering of peaks, but yet collecting enough to cover their plant.
You can negotiate.
Yeah. Oh, no, I know. It has to be designed in good faith. I think just going back to Judge Bell's question, I'm looking at the definition of 1.23.
Yep.
And it says full requirements electric service. And that sort of supports the argument that Appalachian was making, that it may fluctuate in real time to serve customers' retail load. And so I think his argument is that the sale is not a static sale of the quantity, but it's a sale of the quantity at a given time. It says let's see what it says. It means a supply, full requirements electric service means a supply of firm energy to be provided by the company to the customer at the delivery points, as the same may fluctuate in real time to serve customers' retail load.
Right, and I would point to
Of course, the other side is that the load is being adjusted by the battery, which was their power.
If I could pick up on that, both that language and the language in 3.1C, in the Craig Botetourt, it's JA36, actually the relevant language is JA37, that there can be changes in retail load arising from, and it lists a few kinds of fluctuations. And the commission specifically addressed this in, for one place is paragraph 33, which is from JA 363 to 64, where it says the agreements don't include any term. Oh wait, okay. So at the top of JA 364. The agreements recognize that the customer's retail load may change and contain no limitation on how the customers can effectuate such variation. And the commission found that important. That was the third thing I said the commission looked at. It looked at generation, exclusivity, and then it went on to say, are there provisions in this, are there terms in this contract that limit your ability to effectuate fluctuations? And there just aren't. And that's why the commission interpreted the contract the way it did, for those three reasons. But the third one's very important, where it looked through the contract to see are there minimum purchase obligations, are there timing, like minimum peak obligations, are there any limitations on how the customer, meaning the city or cooperative, or Virginia Tech in that agreement, but in these, the city or cooperative, can effectuate the variation, and it just isn't in there. And it could be, you could bargain for it, but this contract as it is written, it's not in there, and that's what the commission concluded.
All right. You've gone through a red light and
sorry.
you didn't get a ticket.
I'm sorry.
All right, Mr. Kaiser.
Thank you.
Thank you, Your Honors. A couple of points on rebuttal. First, I just want to clarify, just to make clear, and it may have been unclear, that when I talked about the standard of review that we believe applies, we believe it's de novo. And so I know I went on a little bit, but don't know if that came across. The other thing I want to talk about, counsel for the FERC mentioned that talking about storage being available at the time and it wasn't put in this agreement. And I would argue that that cuts both ways, right? So in the Virginia Tech agreement, and this is something that Commissioner Danley cited in his dissent, that storage was available, it was known. The fact that it isn't in here as existing generation, as it was defined in that agreement, the Virginia Tech agreement, means that the parties didn't intend to have it in here, right? And that's why we keep coming back to 3.1A.
That's a pretty good argument, except that I don't know how you look at other contracts and imply that in a given contract. I mean, they're at different times and with different parties, with different needs and circumstances, and it could be there could be a very complex decision as to why you allowed it to Virginia Tech and not otherwise, or just allowed it, and that doesn't seem to carry too much. I think we should stay with the contractual language here, don't you think?
I agree with you, and what I would refer you to when you're talking about 3.1C, what we're talking about, and you actually should look at 4.6D as well, or 4.6A as well, because what we're talking about are the types of load-reducing vehicles available that could impact the power that's being taken by the customer. And so we're talking about existing generation in C, we're talking about power purchase agreements in C, and then if you look at 4.6A, we're also talking about less the capacity provided to customer by SEPA. Sorry, I'm jumping around. That's at JA 108 and JA 101. So what the contract does contemplate is what were the parties considering at the time that would be used in a way that would substitute power from the power taken by Appalachian Power. And so, we've got the existing generation.
You go back and you interpret the battery electricity supplied at peak hours. Mm-hmm. The argument is that is Appalachian Power because it was put into the battery by Appalachian Power's energy and was sold at the rates then applicable. The difficulty is cost allocation because you purchase it in off hours at a lower price than you purchase it at peak hours, and your facilities are created for peak hours, and if you reduce all the peak hours, then you now have a larger facility than you need, and if you reduce it, you may not have enough. I mean, I understand some of these problems. I don't understand them fully, but I understand the points you're making. That still raises a question, is the operative language is directed to whether this is an exclusive supply contract and whether that was satisfied. And the question then is whether a battery violates the exclusivity aspect. And the exclusivity aspect seems to be defined in 3.1C, and you're saying it has to be informed by 3A and 4.6.
3A, but you can't lose sight of the two definitions that I highlighted because those are important, right? When we're talking about full requirement service, it's a supply of energy, but it's supplied at real time, and it's to serve customers' retail load. 1.23, that is correct, and that's a JA 96. The other thing that I don't think we can lose sight of is 1.45, which defines retail load. So and counsel for the commission was talking about how there can be fluctuations in the contract. But those are fluctuations by the end-use customers and retail load. So we have to serve retail load in real time. And retail load is defined by the customers, in this case the city's end-use customers. And at the time of peak, when you're using that battery to fluctuate the power that's being taken from the company, you're not fluctuating the end-use customer's use. They're still using the same amount of power. We're just not supplying it at that time. And so that...
You supplied it. It's just not
at that time. And that's a critical point because we need to make the investments necessary to be able to serve all the needs at that time, whether or not those batteries exist. I'm out of time.
Okay.
Thank you.
All right. We'll come down and greet counsel and proceed on to the last case.
May it please the court, Andrew Pincus for Citibank. This case requires the court to address 3 federal laws: the Federal Arbitration Act, the Service Members Civil Relief Act, and the Military Lending Act, to determine whether and how the Arbitration Act's protection of arbitration contracts has been overridden by either of the 2 other statutes. To start, Citibank deeply respects the nation's service members, honors their service, and it's gone above and beyond the law in protecting them from credit card interest rates and penalties, and denies the allegations in the complaint. But the issues before the court today are entirely legal. And I'd like to start, if I may, with...
I appreciate your recognition of that, but I had not thought that this case would challenge rights, positive or negative, for the military. It just changes. It's an issue of forum.
It is, Your Honor. It's an issue of what we think are the substantive protections that the FAA provides to arbitration agreements.
We're assuming the military will still get there.
I think the rights and the individualized relief that are promised in those statutes are the same whether they're in court or in arbitration. Your Honor is exactly right. So starting with the Relief Act, the question here is whether it overrides the FAA. And the Supreme Court has repeatedly held that parties arguing that the FAA has been displaced by another statute bear a very, very heavy burden because of the strong interest in giving effect to both laws. And plaintiffs can't carry that burden here. And second, even if they could, the law doesn't apply to their credit card agreements and the arbitration agreements they contain, because those agreements were entered into before the enactment of the law, and under the Landgraf analysis, that law is not retroactive. So I'd like to begin, if I may, with the first point.
It's not retroactive. What does it mean, notwithstanding any previous agreement to the contrary?
We think that
that sounds pretty backward looking to me.
Well, I think that kind of language is pretty common in the arbitration context, because usually arbitration prohibitions of arbitration agreements enforceability are about pre-dispute arbitration. So it's about arbitration agreements entered into before the dispute arises. And so we think in this context, that's what prior agreement means. It means an agreement that was entered into before the dispute arose. And what that provision is saying is that outside the arbitration context, that kind of agreement that prohibits waivers of class actions would not be enforceable. So we think that's the logical reading, and we think it's certainly, at most, it's ambiguous, and ambiguity.
Well, it creates a little bit of a different problem. I don't know either side said it, but that provision addresses only class actions under Rule 23. And it does not address arbitrations. So the question is, if there's an arbitration that prohibits class actions, the most could be argued that the arbitration would have to be a class action arbitration. But that argument is not being made. It's basically we're focusing on arbitration. Now, if it doesn't prohibit arbitration, but only prohibits class actions, then the question is, we're in arbitration, and what rules do we apply, what clauses do we apply to determine the scope of arbitration? And it seems to me the FAA would require us to apply the contractual language, but
we agree, Your Honor. Your Honor is addressing the antecedent question: does the Relief Act displace the FAA? And we think, for the reasons that Your Honor just gave, it doesn't say a word about arbitration. The provision at issue starts in a civil action, and as Your Honor said, the subsection, the paragraph about class waivers refers to the federal rules, which both of those things, the in a civil action and the reference to the federal rules, indicates pretty strongly that this is about waivers that apply to class actions in court and doesn't have anything to do with arbitration. And we think that means that the arbitration agreement is enforceable according to its terms, and that therefore the term that prohibits class procedures is enforceable, and the term that says if a party seeks arbitration with respect to the dispute, that's enforceable. The Supreme Court addressed that very question in the Epic Systems decision. The argument there was that the National Labor Relations Act precluded class waivers in arbitration with respect to certain kinds of claims. And the court, the Supreme Court there said that because class waivers, individualized adjudication is a critical element of arbitration, that displacing that would displace the FAA, and that in the absence of that, the full arbitration agreement is enforced. So,
But the amendment entitles the plaintiffs to some form of class relief, but the arbitration agreement prohibits that. So, which controls?
well, I think the question that has to be decided is, I think the FAA controls, and the FAA would, putting the Relief Act to one side for one moment, the FAA would say that the arbitration agreement is enforced according to its terms, and so there's no class proceedings. And so I think...
To include a later statement by Congress clearly saying that they have a right to class actions?
Well, I think what they're saying is, in the context of cases that are in court, it doesn't deal at all with arbitration, we submit. In the context of cases in court, a waiver that is not in an arbitration clause, and as we discuss in our briefs, there are a number of contracts that have what we'd call naked class waivers. They're not in connection with arbitration. They just say the parties cannot assert class actions. We think that's what Congress was aiming at here, and the language is certainly not specific enough to override the FAA, because the Supreme Court in CompuCredit and Epic Systems has been very, very, very clear that it's an extremely heavy burden to override the FAA, and that to do that, basically the court has rejected any argument and has indicated in both of those opinions that the way Congress does that, if it wants to, is to specifically mention arbitration, and it didn't do that here. It did do it several years later in the sexual harassment statute that it passed. It specifically talked about both arbitration and class waivers. And so we think the answer to the first question here is the arbitration agreement is enforced according to its terms, because this provision only applies to naked class waivers that are not in the arbitration context, but just say you can't bring a class action in court.
Well, assume you're wrong. What do you say about the retroactivity issue?
I think with...
And our decision, I'm done.
I think the critical distinction between the cases that my friends on the other side rely on, including Hamdan, is that those didn't involve contractual provisions. Here we have a contract provision that specifically protects, that calls out for arbitration, and we have a specific federal statute that protects that provision. So we think that is a dramatic difference from cases that just involve the question of whether a change in procedural law doesn't involve anything codified in a contract, applies retroactively. Courts have generally said, yes, that those generally may. But here we have a contract provision calling for arbitration, calling for individualized dispute resolution, and we think the retroactivity issue is whether that contract provision can be overridden. And so we think that's a totally different case from Hamdan and the other cases that our friends cite. Just to underline the case about the contract provision, I think the reason the existence of the contract provision is so important is that that's what Landgraf calls out as sort of a critical protection. And that's what present here. And as I say, critical also is that Congress thought these contract provisions were so important that it designed a statute specifically to protect them. So we think that makes clear this is a substantive right, it's a contractually protected right, and something that the very tough standard of Landgraf would have to be satisfied to override it. And there's really no serious argument here. As Judge Bell said, asked the question about any previous contract. We think at most that's ambiguous. We don't even think it's ambiguous, but at most it's ambiguous. And in this court's Jack Horrig case, it said ambiguous language is not enough to satisfy the Landgraf standard.
What do we do with the non-SCRA claims?
We think there's no serious argument that the non-SCRA claims could be affected by this provision. Again, the provision that my friends rely on says in a civil action, it then talks about the specific kinds of relief in the first two subparagraphs, the specific kinds of relief that are available. in SCRA cases, and then it has this class action and class waiver provision in the third. So it's clear that what Congress was doing there was specifying the elements of the cause of action in court under the SCRA, and so to say that that could apply outside the SCRA context, we think there's no basis for it. The few cases that have done that my friends rely on based on the sexual harassment statute rely on very different language. They talk about that language talks about a case, very different than in a civil action.
Well, it seems to me a more powerful argument is if you read the section, it says, any person aggrieved by a violation of this chapter may, in a civil action, 1, 2, and 3. And so if you're filing a civil action, 1, 2, and 3 apply. But that has nothing to do with with arbitration with the thing. And so it's basically saying in 3 that in a civil action, you can't waive the class action. They can bring a Rule 23 class action. But the operative language is above. It has it laid out, may in a civil action dash, and then it has 1, 2, and 3.
We totally...
So everything is restricted to in a civil action.
We totally agree, Your Honor, and the Supreme Court in the CompuCredit opinion discussed this and explained that it's commonplace for statutes to specify, create civil causes of action, and to describe the details, and that kind of language couldn't possibly be sufficient to displace the FAA, the court said, because if...
The court has basically said you almost have to say explicitly that arbitration is overruled because the Arbitration Act exists, and you don't imply one act over another. You read them harmoniously, and they pointed out in their Epic case, half a dozen cases, statutes where it suggested that there's no arbitration, still there's arbitration.
I think you're absolutely right, Your Honor, and in both the Epic case you referred to and in CompuCredit, the court said Congress knows how to overrule, to displace the FAA if it wants to, and that's by specific, and the examples that it gave were specifically mentioning arbitration. So I think the court has been, as you say, very clear on this. I'd like to...
So your argument is essentially that the arbitration agreement has prevented class action in any form. Because by
Yes.
agreement, you can't bring a class action in arbitration. And you're saying that the Service Members Act doesn't allow them to take it to federal court.
That's exactly right, Your Honor, and that was the holding of the Supreme Court in Concepcion, where it first discussed this question of the FAA's protection of class waivers, and we talk about the Cruz and Conniff cases that followed up on that and said, the argument was made, in Concepcion, maybe the Supreme Court just said you can't bring class proceedings in arbitration, but you could still bring class proceedings in court, and both of those courts rejected that argument and said, no, the provision of the arbitration agreement, two provisions are enforced. One is the provision that says no class proceedings, but the other is the provision that says disputes will be resolved if one party asks in arbitration. So those two provisions combined create the result that Your Honor referred to, and it's something that the Supreme Court again reaffirmed in the Epic Systems case, where the argument also was made, if the arbitration agreement precludes class proceedings, then it must be that class proceedings are allowed in court, and the court squarely rejected that argument. I'd like to turn, if I can, to the MLA argument, because I think that statute is a little complicated, and I wonder if I can just say there, DOD repeatedly said in conjunction with the promulgation of the regulation that credit card opening is the relevant moment for determining MLA coverage, and that determination applies for the life of the account. And the accounts here were opened prior to the MLA applying to credit cards, and therefore it doesn't apply here. And I think it's obvious why the Secretary said you can make a life of the account determination at account opening, because the system would be totally unworkable if that didn't happen. So I think the effective date provision is 32 CFR 232.13. It says, notwithstanding the new broader definition of credit that the DOD adopted, until October 3rd, 2017, consumer credit does not mean credit extended in a credit card account. All of these accounts were opened prior to 2017, so we think that's dispositive. And the argument of my friends on the other side depends entirely on the proposition that a credit card account not covered by the MLA then when it was opened will somehow become credit subject to the MLA based on subsequent use of the card. But that's the precise interpretation that the Secretary repeatedly rejected. We have those statements in our opening brief on pages 57 to 60. And it would be unworkable and unfair. And I think something in the regulation that makes clear that the Secretary didn't intend to do that is the critical safe harbor provision. Because the safe harbor provision says that a credit card issuer can determine at account opening the status and that determination will apply for the life of the account. But the safe harbor provision critically can't be used with respect to accounts that existed prior to the MLA's effective date because the relevant provision, 232.5b3, says that only at the time a consumer applies to establish the account or 30 days prior to that time can the credit card issuer use the DoD database to make that conclusive determination. And if the Secretary thought that pre-effective date accounts could become subject to the MLA, certainly he would have provided the safe harbor. He did not. Thank you.
All right. Ms. Nichols, I guess you're first.
Good afternoon, and may it please the court. My name is Leah Nichols, and I represent the service member appellees. Under the plain text of Section 4042 of the SCRA, the class action waiver in Citibank's agreement is not enforceable, and the district court's decision should be affirmed. But even if this court disagrees in full or in part, none of the service members' claims can be compelled into arbitration under Section 987 of the Military Lending Act. Beginning with the SCRA, I want to address a point that Citibank brought up just here, which is that implying that because the text of the statute talks about a civil action.
It doesn't talk about, it authorizes only in a civil action. It says you may, in a civil action, have those things. And then if that weren't clear, Rule 23 does not apply to arbitrations. Rule 23 is a federal rule that applies in civil actions.
Your Honor, with regard to that first part, in a civil action, the problem with the argument of saying, okay, well, it says you may in a civil action, and then saying, well, everything under that can be displaced by, it's
not displaced. It authorizes if you file a civil action, dash 1, 2, and 3. So those 1, 2, and 3 are subservient to that, a part of that sentence. You may, in a civil action, do A, B, or C, or it's actually 1, 2, or 3. And it seems to me it's providing a remedy of a civil action, and in that civil action you can do these things. But there's nowhere that it says it prohibits arbitration. Now, arbitration is not a class action. Arbitration is a contract to arbitrate, and under the terms of the arbitration, they don't resolve issues on with class proceedings. But there are no rules. Rule 23 doesn't apply to arbitration.
Absolutely, we agree, Your Honor. But I want to start sort of with this idea that because it says you may in a civil action, and then it lists the remedies, if the idea is nothing under there applies.
Civil action, why'd they put that in? In other words, 1, 2, and 3 are relating to when you file a civil action.
Yes, Your Honor, but here's a situation. A lot of different statutes use that language. So, for example, in Gilmer, the ADA began with the same exact phrase. Any person aggrieved by a violation of this chapter may in a civil action. And the Supreme Court did not say, well, because there's an arbitration agreement, everything under there disappears. That is not what...
The Supreme Court would address this totally differently. The Supreme Court would say we have two congressional statutes, the FAA and the SCRA. And they would say one does not overrule the other. And this does not even purport, doesn't even mention the word arbitration to overrule the other. And the Supreme Court has required some explicitness. So it seems to me you read the two together, and every time they've done that, every time they have allowed the arbitration to go ahead. And there's a list of cases in Epic where they've done that, and it's a goodly list.
Your Honor, I want to parse out sort of two different things that are going on in two different arguments.
That's what the Supreme Court would rule on it. I'm just suggesting that when a statute provides remedies in a civil action, it doesn't suggest it's providing remedies in arbitration or in some other mechanism, mediation or some other mechanism where the claim is brought. It says when it's in a civil action, it's A, B, and C. But I'd suggest the bigger picture is the Supreme Court's effort to harmonize FAA and every other statute. And it says there's nothing to indicate that the FAA is to play a lesser role. As a matter of fact, they suggest that the FAA has to be given a robust role.
Your Honor, I think I agree there's two separate points. With regard to the first point, I think that's incorrect because the remedies that are available after a civil action are still available in arbitration. There would be no private right of action if there were an arbitration agreement, if that were true. Gilmer would not, the rights in Gilmer under the statute would not apply in arbitration if that were true. So I think that's not how we can read the statute. I think it's directly contrary with what the Supreme Court said in Gilmer, which involved the exact same statutory language. 42
prohibits arbitration?
Yes.
Tell me what word addresses arbitration.
Your Honor, it says, well, let me back up. What it says is you have the right to bring a class action.
No, I'm not, don't go to the class action because we're talking about a bigger picture. We're talking about what forum you're in, not what type of proceeding. What forum are you in? You're either in a contractual arbitration or you're in court. Now, the question is, does this prohibit you from going out of court and resolving it in arbitration? And the answer is clearly no.
Your Honor,
and what it does, your argument is it prohibits class actions since the arbitration clause has a class proceedings limitation. It therefore applies. The most you can get out of that is that the arbitration clause should be modified by this statute so you can't go with a class proceeding and do an individual, have a class proceeding in arbitration. That's a whole different issue. You're saying basically the arbitration clause should be modified by this. But that's a strange bird because it doesn't address arbitration contracts, modifying them, number one. And number two, Rule 23 doesn't apply, and this is clearly refers to class actions under Rule 23.
Your Honor, what it says you have the right to bring a class action, and that cannot be waived by any previous agreement to the contrary.
Right, you win. So now we have an arbitration where there's a class proceeding. You haven't gained a thing.
Your Honor, three responses to that point. One, there's an anti-severability clause in the arbitration agreement in this case. And so what the Citibank's anti-severability provision says is that if anything in the agreement is rendered unenforceable, including the class action waiver, then no arbitration at all. So in this case, that gets resolved.
What's the exception clause say?
Sorry?
There's an exception clause to the severability clause.
Right, there's an anti-severability clause in Citibank's provision. And what it says is
if it's declared invalid.
Right, it says if any aspect of the arbitration agreement is declared invalid.
You think this language says arbitration agreements cannot contain class proceedings because class proceedings are authorized here in federal court and they can't be waived in federal court?
This provision says class waivers are not enforceable wherever they appear.
It doesn't say wherever. It says
It says
civil action, number one, and number two, under Rule 23.
It says in any previous agreement to the contrary. And
oh, you're talking about the arbitration agreement. I was focusing on the statute. Yeah.
Right. Yeah. So it says, the statute says any previous agreement to the contrary. There's no limitation on that. And I want to be very clear, right? This happened, this provision was passed after AT&T versus Concepcion. So Congress was well aware that generally, class waivers.
The problem I have is we have an FAA, and we can argue what the FAA allows or doesn't allow after you get in arbitration. But you have two statutes, one that creates arbitration forum and the other this one creates a civil action. This does not prohibit arbitration. Under your argument, it prohibits class actions.
That's right.
And it prohibits class actions. So now you have to construe this provision that says prohibits class actions, that it means it prohibits arbitrations. And it doesn't say that.
It says any agreement to the contrary. Now, I want to, a couple of points I'd like to make. One, in terms of trying to harmonize these two statutes, right? Congress was well aware that not only are there standalone class waivers, but there are also class waivers in the context of arbitration agreements. And to say, well, okay, this provision is...
Class actions, in the traditional sense. They're class proceedings where they purport to represent non-individualized treatment. And the agreement basically wants to have individualized treatment. And of course, the Supreme Court addressed that whole issue, said we abide by the terms of the contract. You can't invalidate it unless it's declared illegal, and this doesn't declare arbitration clauses illegal of any kind because the Supreme Court's expressly affirmed it.
All right, I mean, our view, and I think, it says any previous agreement includes any previous agreement. Now, I want to go to the point about what the Supreme Court has done in Epic Systems and what this court has done in Lyons. So in Epic Systems, what the court said is that Congress overrides the general rule that arbitration agreements are enforceable by explicitly identifying, quote, what rules should govern the adjudication of class or collect actions in court or arbitration, and does the statute mandate particular dispute resolution procedures that are inconsistent with arbitration? It said, did Congress expressly depart from the usual rule that parties can contract to adjudicate claims differently? And Congress did exactly that in the SCRA. It meets all of the requirements that Congress said it had to meet in Epic Systems. And I think if we contrast the SCRA with the NLRA, which didn't specifically talk about class actions, it created no unwaivable right to bring a class action, which is what the SCRA did. These are very different statutes.
Very different statutes, and for you to gain any ground, you have to suppose that the SCRA overruled a right to agree under the FAA in the manner that the arbitration agreement in this case provides. And the Supreme Court has said when two statutes stand side by side, we do not imply that one overrules the other unless it does so explicitly. And that unless you understand that under Epic or all the other decisions that they've had. They've been through this, in half a dozen more cases.
Yeah, Your Honor, they've never said that the word arbitration is required, but I want to switch to looking at this court's decision in Lyons. In Lyons, PNC made a very similar argument to what Citibank makes here, which is that the particular provision at issue in Dodd-Frank and Lyons itself did not discuss arbitration at all. What it said is that we're not going to enforce an agreement that takes away the ability to bring your case in court. And this court looked at that and said, yeah, that's enough. That's a contrary congressional statement. And so if this court follows its own reasoning in Lyons, I think we get to the same place. Now, I want to...
Now, in Lyons, of course, it was ruled that there was no bar to bringing an action in a, quote, appropriate district court of the United States, which is not the language used in the SCRA.
Right, that's because the SCRA is focused on class actions. To be very clear, there's nothing in the SCRA that prohibits the enforcement of an arbitration agreement when the person is bringing individual claims, right? So it's just doing it's not looking at saying, oh, we want everything in court versus arbitration. It's saying we want class actions to be able to proceed. And so an agreement to arbitrate is absolutely enforceable in the context of the SCRA where there are only individual claims. And so Congress is just doing something a little bit different there. But I want to move on to the Military Lending Act, if I might, because if you disagree with us in full or in part with regard to this, with regard to the SCRA, the district court's order denying Citibank's motion to compel arbitration should be affirmed for another reason as well, and that's because Section 987 of the Military Lending Act prohibits imposing or enforcing an agreement to arbitrate any, quote, dispute involving the extension of consumer credit against a service member. Now, there's no dispute here that the MLA is a contrary congressional command that displaces the usual enforcement of arbitration agreements. The dispute boils down to what is the use of a credit card to make a purchase an extension of credit? It is, because the Supreme Court has said so. In Kerner, in the very analogous context of TILA, which also involves consumer lending. And what the Supreme Court said is interpreting the definition of credit under TILA and said, look, part of that definition includes incurring a debt and deferring its payment. And that is exactly what you do when you use a credit card to make a purchase. And so there,
DOD regulations sort of define it otherwise, right?
the definition of credit that the Supreme Court interpreted in Kerner is exactly the same as the definition of credit in the DOD regulations. There are some consumer credit's a little bit different, but with regard to the definition of credit that Kerner is interpreting in TILA, it is exactly the same definition, word for word, that's in the DOD.
Not credit alone, extension of credit.
Extension of credit is used exactly the same in TILA as it is in the Military Lending Act, not even in the regulations. But extending credit and extension of credit, Congress put in MLA, used the same exact phrase that was used in TILA, and obviously it can be presumed to know about the Supreme Court's interpretation in Kerner when it did that. And again, the definition of credit that the Supreme Court is interpreting is exactly the same in the DOD regulations as the definition is in TILA. And so if there are no further questions, I see I'm out of time.
Okay, thank you.
Thank you.
All right, we have an amicus, Mr. Wang.
May it please the court, Christopher Wang on behalf of the United States as an amicus supporting plaintiffs. In my limited time, I would like to address section 4042A3's text and the relevant precedent, but I'm happy to answer any other questions the panel may have. Section 4042A3's phrase, any previous agreement to the contrary, is read most naturally to encompass all previous agreements, including arbitration agreements, thus showing Congress's clear intent to...
You start with a little clause in subpart 3, but you have a statement up at the above which controls all three of them, may in a civil action. And then you have three things which you may do in a civil action. It's an authorizing statute. And then it says you can bring a class action, and not only that, you can't waive that class action, and it defines class action under Rule 23. Now, that's the full context. You can't just read any agreement. You got to read it in the fact it's in a civil action, and it's under Rule 23.
Your Honor, I think Citibank's argument goes too far. Section 4042A provides a private right of action for aggrieved individuals to recover equitable and declaratory relief and monetary damages. Under Citibank's logic, a party could waive their ability to acquire such remedies through arbitration, which we believe is contrary to the Supreme Court's holding in Viking Cruise Lines that a part.
You think this section prohibits arbitration?
We do.
What's the language you say precludes arbitration? Forget the class action.
The phrase "notwithstanding any previous agreement to the contrary" we believe is broad enough to cover arbitration.
I said that's a class action waiver. I'm saying let's assume, just hypothetically, that this arbitration agreement had nothing about class provision. It's an arbitration agreement that said you have to arbitrate your claims. And does this statute prohibit arbitration?
Well, this statute only applies to class actions. It does not apply to individualized arbitration.
It does not just apply.
It doesn't apply to individualized arbitration.
May bring a class action.
Yes, it authorizes a class action.
So, does it prohibit arbitration?
It does not. It prohibits arbitration in the context of a class action, not in the context of individual.
I didn't ask you that, did I? The hypothetical was, do we have an arbitration agreement that has no class proceedings provision in it? Now, does it prohibit arbitration in that circumstance?
Your Honor, I haven't thought about that question. Just at first blush, I don't.
The whole issue is whether the FAA applies or the SCMRA applies.
We believe that
This man has a claim under this statute, and he has an arbitration agreement. It doesn't have any provision with respect to class actions. He just has an arbitration agreement. Doesn't he have to arbitrate?
He has to arbitrate his individual claims. That's correct, but not his class. This carves out.
And why is that not, where in this statute doesn't prohibit that, does it?
Well, it prohibits arbitration, prohibiting an individual from bringing a class action in district court just for class actions.
Of course, there's no class actions in arbitration, are there?
Generally, no, not in this particular arbitration.
Not generally, in any.
Yes.
I mean, it's a contractual provision, and what some people have tried to do is to represent others in the arbitration. But Rule 23 doesn't apply there.
And I would say in most cases, most arbitration agreements have a prohibition on class-wide arbitration. But to go to Judge Floyd's point, we also think that Section 4042A3 does require that someone be able to bring a class action in some form. In that case, that's district court in this case because arbitration.
So the claimant comes in and he says, I want to file a class action. And the defendant comes in and says, you have an arbitration agreement, no reference to class actions in the agreement, and ask the court to compel arbitration. You've agreed that arbitration would proceed, right?
If he wants to bring a class action, the SCRA says that he should.
He says he wants to bring a class. He files a class action, and the defendant files a motion to arbitrate, and the arbitration agreement has no provision on class proceedings. And you've agreed that he has to arbitrate, right?
Well, he has to arbitrate individuals. We believe that the SCRA is sufficiently broad to cover class actions to authorize him to bring a class action in district court.
He's authorized to bring it. But if he signed a contract to say, I agree to arbitrate my individual claims, or I'll bring a class proceeding in the arbitration. But you've agreed that the statute doesn't prohibit arbitration.
It does not prohibit arbitration. If he chose to bring an individual claim, he would have to arbitrate it. Class actions are.
Now your argument comes that if he has to arbitrate, because the FAA says he has to arbitrate, and it says it's irrevocable, and they have a bunch of adjectives about these agreements, very, very strong, which the Supreme Court has robustly interpreted. He now has to arbitrate. Now the whole question is, can he do it on a class basis and represent others or individually? And it seems to me that would be under the law of arbitration, the arbitration agreement, Supreme Court's decisions, and so forth. But once you're in arbitration, if you're entitled to go to arbitration because the statute doesn't prohibit it, you sort of give away the ship, don't you?
Well, Your Honor, we have a disagreement about whether the statute requires one to go to arbitration. Our entire point is that this phrase, notwithstanding any previous.
You're backpedaling. This man files a class action under the SCRA. He has an arbitration agreement which makes no reference to class actions or class proceedings. It just says you agree to arbitrate. And you've agreed that the defendant can come in and enforce that agreement.
Enforce it for individualized arbitration, not for the class action.
Well, there is no class action on it, so you can enforce it, and he goes down to enforce it, and then he says, I want to represent a whole class of people before the arbitration. And the arbitrator says, no, you can't do that. We don't have class proceedings here. What do you do then?
Well, I think the whole point of the Section 4042A3 is to enable such a party to file a class action in district court. And once again, he has to meet all the requirements of Federal Rule of Civil Procedure 23, which are not insignificant. So, I mean, certainly there's a carve-out, we believe, from the general policy favoring arbitration for class actions.
There's a carve-out for civil actions in federal court under Rule 523.
Yeah.
Okay, thank you.
If the panel doesn't have any additional questions, I'll rest on the briefs. Thank you.
Thank
you, Your Honor. Just a few quick points. First of all, on the Relief Act issue, I think the Supreme Court did supply a roadmap. It's not the one my friends are talking about. In both CompuCredit and Epic Systems, it said Congress knows how to displace the FAA. It specifically refers to arbitration. We quote those on pages 9 to 10 of our reply brief. In this court's Lyons case, the word arbitration was in the heading of the provision, and that's something that the court actually relied on. I think it's significant here to the extent my friends are arguing that Congress couldn't possibly have wanted to draw this distinction between class waivers outside of arbitration and class waivers in arbitration, that the legislative history shows that the House passed a bill that had two provisions. It had this provision we're talking about, and it had provision banning pre-dispute arbitration. The final bill only had the class waiver provision. So Congress had before it an example of what has to be done to displace the FAA, and it just didn't do it. My friends make the argument that paragraphs 1 and 2 supply individualized remedies, and our argument would mean they don't have to be available in arbitration. Not true. The FAA doesn't displace individualized remedies. In fact, it requires that individualized remedies be available in court. And so that's with respect to the Relief Act. With respect to the MLA, I think my friend didn't mention the critical effective date provision that I mentioned. And I think the other thing that's important here is that the Secretary's regulations are not a carbon copy of TILA. The Secretary is not required to do that. Section 987H2E gives the Secretary the power to impose additional or different limitations.
What's the regulation say?
The regulation, the applicability section of the regulation, 232.2A1, the second sentence says, nothing in this part applies to a credit transaction or account relating to a consumer who is not a covered borrower at the time he or she becomes obligated on a credit transaction or establishes an account for credit. Establishes an account for credit obviously is targeted at credit cards. My friends say, oh, but the obligated on a credit transaction provision must mean that every time you use your credit card, another determination has been made. But the Secretary's statements that specifically disavow that in the preamble to the regulation at 80 Federal Register 43579 and Note 168 on that page specifically say, with respect to that provision, that the relevant language is establishes an account for credit cards. The other language, obligated on a credit transaction, was there before. The Secretary added that second phrase specifically to address credit cards and specifically to make clear, as the safe harbor provision does, that a credit card issuer can make a life of the account determination at the time the card is opened. That's how the safe harbor works. And it has to work that way because disclosures and other obligations are triggered by the application of the MLA, in addition to the prohibition on arbitration. And the Secretary recognized that credit card issuers need to have a time when they can be certain that it may apply or that it doesn't apply, and that's the purpose of that regulation. Thank you.
All right, I think that covers everybody. We'll come down and greet counsel after we adjourn court for the day.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.